on NRI taxation and FEMA obligations. We are delighted to welcome our first session speaker, Dhanush D Bolar, to the dais. Please rise for the motto song. Lakshmi to introduce his speaker.
Morning all. I'd like to introduce Mr. Dhanush D Bolar, the first speaker of the day. He is a practicing chartered accountant and a partner at Mrs. Nitin J. Shetty and Group Control. He has been an associate member of the Institute of Chartered Accountants in India since 2019. With a strong background in direct taxes, tax planning, audit emissions, and foreign FEMA balances and advisory. He specializes in corporate audits, direct tax, and FEMA advisory. He has been handling income tax assessments before the income tax authorities and appearing before the Directorate of Enforcement. In addition to his professional expertise, Dhanush has completed a study course on FEMA conducted by the Bombay Chartered Accountants Society and the course on Penalties. He is also a guest lecturer at various institutions and has been featured multiple times on the YouTube channel NRI Money Clinic, where he discusses various aspects of FEMA and its implications for non-residents. His expertise is further demonstrated through the numerous articles he has authored on taxation and FEMA in various forms. Welcome, sir.
Thank you.
Thank you, Lord. We kindly request Sri Lakshmi to adopt this order and present the moment.
Thank you.
Thank you, Lord. Forward to the speaker.
Good morning, everyone. Without wasting much time, let us start with this session. The topic we are going to cover today is the objective of the FEMA. Because the first 15 minutes I covered the basics of the FEMA. What is FEMA? What are the sections and how many? What are the master directions, APDL circulars? Then we'll go deep into the main subject, the core subject of today's topic. The person resident in India, person resident outside India, current account transaction, capital account transaction, NRIs, obligations for immigrating Indians and returning NRIs, purchase and sale of properties in India and outside India, and borrowing and lending regulations. See, the FEMA is not drafted in a user-friendly manner. There are no specific regulations covering all types of transactions. If you want to check applicable regulations on a specific type of transaction, you may have to check the applicable rules, applicable regulations, applicable master directions, applicable circular, and so on and so forth. So, earlier there is a law called FERA. The main change that has been brought in is FERA was a civil law. FEMA is a civil law, whereas FERA is a criminal law. FERA was known for its draconian provisions because there was presumptions that everyone was guilty unless proved innocent during the FERA regime because country had a little foreign exchange reserves post-independence. But the main shift from FERA to FEMA is shift from control of foreign exchange to promotion and orderly development of foreign exchange. As mentioned in this slide, the objective of the FEMA is to facilitate external trade and payment by way of framing rules, regulations for various stakeholders like companies or partnership firms, proprietors, and also promoting and developing the foreign exchange market in India by way of framing directions to the authorized dealers banks in India. Structure of the FEMA. See, FEMA Act. FEMA has only 49 sections. So you may feel that you don't have to read much like Income Tax Act. But under FEMA Act, the first 9 sections are the substantive provisions, cover substantive provisions, and rest all are procedural and administrative. So if you want to refer applicable FEMA provisions for particular kind of transactions, you will not get anything in FEMA Act. Because FEMA Act covers the first 9 sections, covers only the general provisions. You have to refer the applicable notifications, applicable regulation, applicable rules. For example, for overseas investments, you have to refer the overseas direct investment rules, overseas direct investment regulations, and the master directions on that. And similarly for FDI, you have to refer the non-life instrument rules. In FEMA Act, you not get anything. The FEMA Act covers only the general provisions. Section 37A, which is the important sections because it gives the power to seize the equivalent value of Indian assets for overseas assets by foreign exchange, foreign security, immovable property, suspected to have been held outside India, in contravention of Section 4. Then we have Section 46, which gives grants power to the central government to make rules to carry out the provisions. Similarly, Section 47 grants power to the RBI to make regulations to implement these provisions and rules made under this. As I said, these are the basic structure, the main structure of the FEMA. We have FEMA Act, we have notifications, we have rules, we have master directions, we have APDF circulars, effectives and FDA policies. Till now, the RBI has issued around 25 notifications covering various type of transactions, out of which the 15 is on the capital account transactions, 1 is on export and import, and rest, the remaining 9 is on other provisions. And we have rules and we have master directions. As till now, the 20 master directions have been issued. Master direction is nothing but the consultation of rules, regulations, or circular. The master direction should be usually issued by the RBI. Say for example, recently in 2022, the central government has notified the overseas direct investment rules. But what are the procedural aspects is covered under the master directions. So that is issued by the RBI. Then we have FAQs. If there is any some clarifications to be issued, RBI will come up with the FAQs clarifying certain aspects. Then we have FDA policies. The FDA policies issued in 2020. Before that is in 2017. Yes.
Master direction is consolidated.
Yes.
Whatever rules, notifications also will get covered.
Yes.
They will repeat it again.
They will repeat it again. They also cover the procedural aspects.
Whatever was covered till now, everything will follow.
Yes.
They generally say this is the one place where you can refer.
You can refer, yes.
All will get
All will cover. Whenever there is amendment in our rules or regulations, even the master directions will get amended.
So that whether then we need not have to see the rules and notifications, we need to refer to the master direction. How it is.
No, you have to refer the rules, but for to understand more in detail and what is the procedural aspects involved, you have to refer the master directions. The rules may not cover all aspects.
Procedures will not.
Yes, it will not cover.
But the rules are covered in the master.
Yes, it is covered. It is
This
covered.
is over.
Yes. So, when there is amendment in rules or regulations, simultaneously the master direction will get amended. So, this is the structure of the FEMA. Section 1 to the jurisdictions and definitions. Section 39 covers regulations and management of forex. Sections 10 to 12 is authorized person. 13 to 15 is contraventions and penalties. 16 to 35 is adjudications and appeal, and 36 to 38 enforcement and appeal. And 39 to 49 is miscellaneous, that is the power to make rules, regulations, etc. But in this FEMA Act, you don't. These are all general provisions. You don't get anything in specific. You have to refer the applicable rules or regulations. So covered. See, a PDA circular is basically as I said, APDF circular is basically the instructions given by the RBI to the authorized dealer standards. Then we move on to the concept of residence. Section 2B talks about the residential status. Residential status is important because before verifying the applicable rules and regulations, you have to you have to decide what is the residential status of the person executing the transaction, whether he is a resident in India or resident outside India as per the definitions given under the FEMA. Then you go to the applicable rules or regulations. Section 2B, it says that person resident in India means person residing in India for more than 1 or 2 days during the preceding financial year. So if you want to verify the residential status of a person for this financial year, you have to verify the number of days of stay of a person of a preceding financial year, but does not include a person who has gone out of India or stays outside India for taking employment, for carrying on business or vocation, or for any other purpose which indicates his intention to stay outside India for a certain period. That means to say, if a person is living in India for any of these 3 purposes, that is for taking up employment, for carrying on business or vocation, or for any other purpose, in such circumstances which indicates his intention to stay outside India for a certain period, he will be considered as a person resident outside India from the day 1 itself. He will not be a person resident in India. It says does not include. Was stayed in India. So even if he was stayed in India for more than 182 days during the preceding financial year, if he lives in this financial year for any of these 3 purposes, then he will be considered as person resident outside India from day 1 itself. Similarly, a person who comes to India or stays in India, in either case, otherwise than for taking up employment, for carrying on business obligations, again similarly, for uncertain period. That means to say, this is little confusion here, and the 3 interpretation is possible here. I am explaining what is my interpretations by understanding by reading the definition of provided under the FEMA. This section 2B. First, the main link says that a person residing in India for more than 182 days during the preceding financial year. That means, if a person stays in India for more than 182 days during the preceding financial year, he is a resident. Now, more to the clause B. It says, person who comes to but does the main link says but does not include. Then you come to clause B. It says a person who comes to India, stays in India, in either case, otherwise than. That means if a person is coming to India for any purposes other than these 3 purposes, he will not be considered as a person resident in India. Suppose if it is for these 3 purposes, that is for taking up employment, or carrying on for business allocation, or for any other purpose in such circumstances as it indicates his intention to stay in India for a certain period. He is a returning NRI, person who worked in India for a number of years outside India, is coming to India for permanent settlement. He is a person resident in India from day one itself. You don't have to check whether his number of days of stay in preceding years. Similarly, if it is coming to India, a foreigner who is coming to India, he fell sick, he had to undergo some treatment in India, his number of days has exceeded 182 days. Under income tax, he may be considered as a person resident in India. But under FEMA, he is not falling under any of these three purposes. He will go back once he is fine. So he will still be a person resident outside India even if his number of days of stay has exceeded 182 days during the preceding financial year. So this number of days criteria becomes relevant only when a person is living in India for any purposes other than these three purposes. A person is going on any vacation, long vacation, he is not falling under any of these three purposes. So then we have to check whether he has stayed in India for more than 182 days during the preceding financial year. If yes, he is a resident in India. Otherwise, he will be a person resident outside India. Clear? Any doubt on residential status? Because this is most important. This is the first and foremost thing you have to determine before verifying the applicable rules and regulations. If this goes on, the rules also has gone from.
The number of days we get orders that we get
As I said, I am a resident here. I go on a long vacation.
So, resident, it could be less than 182 days or
More than 182 days.
Okay. So we go on vacation.
Yes. I go on vacation. Say, I was there in India for more than 182 days during the 23-24 financial year. In this financial year, I am going on a long vacation. So, for this year, I will be a resident because my number of days in the preceding financial year is more than 182 days. Again, in this 24-25, my number of days is I am in India till say September 30th, which is less than 182 days. So for the next year, since I was in India for less than 182 days in the preceding financial year, that is in 24-25, for the next year, that is 25-26, I will be a non-resident.
So this year's 182 days will not be considered.
No, for this year we have to check the preceding financial year.
Intention plus the
So intention will come into the picture. But my intention is not covered under any of these three.
other than
These three. Yes.
So it's like, for example, say for medical reason.
Medical reason.
Gone abroad.
Yes.
Gone abroad and the stay was less than 182 days. That days need not be taken and all.
That time you have to take days, number of days. Because that is not covered under any of these three.
So for this current year, we need not have to check.
For current year, we have to check, sir. We have to check, huh? See, for current year, we have to check the earlier preceding years number of days stay in. Suppose I am going for medical treatment in this financial year, I have to check last year's number of days of stay in India. I was in India throughout the year. So for this year, I am a resident.
So suppose like I have been there for more than 182 days in this year itself.
Hmm.
So after October I go. So then I need
You?
to have to check for the previous year.
No, we have to check for the previous year.
Still previous year.
Yes. We have to check for the previous year.
Currently I stayed as
No.
what in previous year?
Yes, previous years. So for 24-25, you will have to check 23-24's number of days of stay in India. Similarly, to arrive at the residential status for the year 25-26, you have to check. Yes.
So this year more than 182 days after October I go.
I will still be a resident for the next year.
For next year. But
Yeah.
the previous year had I been less than 182 days, so this year I become a
Non-resident.
even if more
Yes,
than 182
yes,
days.
yes.
Okay, this means-
And this FEMA, the residential status is not for a particular year. It will change depending upon the facts and circumstances.
At that particular moment.
Yes, at that particular moment.
Then why that 182 days?
it's almost become redundant.
What has happened is, most of the cases what we have encountered at that time, we found that a person can be a resident as per income tax act for a particular financial year due to number of days, because it is almost purely based on number of days. But under FEMA, we are not resident. But for a part of the year, because under FEMA it is possible that for a part of the year you will be a resident and part of the year he is a non-resident. That is why in 10(4) there is an exemption for NRE interest. When for that exemption to claim, one need to check the residential status under FEMA, not under income tax. It is starting with the word individual who is a non-resident. It doesn't say that. It doesn't say non-resident use of the word. There is an individual who is maintaining NRE account. He is eligible to claim exemption provided he is eligible to maintain NRE account as per FEMA. So he is eligible to maintain NRE account as per FEMA only if he is a non-resident as per FEMA. So a person coming back to India for a permanent settlement, on the day of his arrival, from there onwards he becomes a resident. So as per FEMA rules and even RBI regulations on NRE account, it says if you are coming back to India for the purpose of taking employment or for permanent settlement, you have to immediately, it is not word 6 months, that and all is not, word is used immediately, convert that account, NRE account, into a resident account. So thereby, it is not again convert, it is redesignation of the account. So account number, everything will remain the same. So interest earned from that day onwards will be taxable. So same way, a person who is leaving India for the purpose of employment will become non-resident as per FEMA immediately on the day of his departure. So on that day he is eligible to open NRE account, and any deposit to that account from that day, interest earned in that NRE account will be exempt. So even though he is a resident as per income tax. So that is where this one, NRE, this one, FEMA regulations and residential status is totally different than income tax.
FEMA, it is from particular date, and income tax, it is from full year. This is the fundamental difference.
But income tax, excuse me, doesn't override FEMA or anything.
So FEMA is a regulatory law.
It is
You don't
for
have
a
to check.
particular transaction.
It's not particular transaction.
This is for particular income of a particular year, income tax. Like. Sorry, sir.
Yeah, no. That's why we have an interactive session, so that's why it will be helpful, yes. So, if one had to verify the number of days of stay in India for 180 days, say for example, a person coming to India for employment. If he is coming to India, say for example, in the month of June 2024, if we had to wait for 182 days to determine what is his residential status, then there will be difficulties. Because once he comes to India, he has to open the bank account. Which bank account to open? NRO or resident account? If he is making investment in India, whether it is NRO under NRO demat account or a resident demat account, there will be difficulties. So that's why under FEMA, the residential status is on a particular date, depending upon the intention of a person who is coming or living in India.
So maybe from that perspective, maybe they are looking at the previous year for people other than these.
Yes, other three, yes.
So have that clarity from
Yes.
the beginning, look at the previous year.
Yes.
1 year, we anyway we will leave it. Let
Yes,
us leave it
yes.
and then have some
Yes.
certainty here. I think that would be.
Yes. So if a person coming here for employment, and imagine he had to wait till 31st March to know his residential status, he is coming to in June. Until that period, what about his the transactions in India or transaction outside India? What regulation has to be seen? So first, we have to check the residential status. Then we go verify the applicable rules and regulation. So that's why In my view, the 182 days criteria becomes relevant only when a person living in India only for other purposes, other than those three. But for all other purposes, you have to check what is the intention of a person.
Can you just say the three employment?
Business or occasion, or for any purpose which indicates his intention to stay outside India for uncertain period.
If a person has to convert his account, NRI account, as NRI account after the new year, that is on 1st April only. That means the status will be known for the previous year, and until the next year we have to wait.
No, sir.
That is the meaning.
No. Yeah, if you're taking this interpretation, you have to wait till 31st March. Then you check what is your residential status from 1st April. Then you open a bank account. What you could do till 31st March? Whether you can open a resident account. So even this interpretation can be further substantiated by there is one regulation, this FEMA notification emphasizing intention. There is a deposit regulation. It says NRI account should be redesignated as a resident account, or funds held may be transferred to the IFC account immediately upon return to India for taking up employment or for carrying on business or occasion or for any other purposes indicating intention to stay in India for uncertain period. So with this para, I can say that the intention becomes more relevant here rather than the number of days of stay. This is an example. A person comes to India for taking up, again, it's already explained, job. Under FEMA, he becomes a resident from the day he comes to India. As a resident, he could do several transactions, but as a non-resident, there will be restrictions. If such person had to wait till 31st March 2025 to know whether he is a resident or vice versa, then there will be difficulties. So under FEMA, a person resident is from a particular date. Under income tax, residential status is for the full year. This is the fundamental difference between the FEMA and the income tax. Considering the residential status. Now, it has given the term uncertain. The law has not defined what is uncertain. The FEMA Act has used certain terms which is not defined in the Act. Even it has used certain terms which is not defined in the Act, but it is defined in the applicable rules or regulations considering the need of the regulations. So this term uncertain is not used in the Act, but there is one decision, RP Verma versus Union, which is 1999. Writ petition was filed by the appellant seeking directions that he should be treated as NRI for a limited purpose of holding assets in UK of his relative. Appellant was citizen of India and has to go abroad to look after his ailing relative. Date of return was not known at the time of his departure from India. His intention was to return to India only after ailing relative recovered. Then his contention was that he had gone to stay outside India for uncertain period, therefore he was not a person resident in India as per FEMA. It was held that this fact was not sufficient to indicate his intention to stay outside India for uncertain period. It was also held that period for which visa was issued to him was also not relevant in this context. So, person who is living in India, look after his ailing relative, still this decision says that also will not be considered as for uncertain period. You will have to provide sufficient evidences, documents to prove that your intention is uncertain.
So he was a resident here.
He is a resident here.
He wanted to stay here for some reason. Specific, again, after the relative was okay, he wants to
Yes, to come back.
So that was stronger.
Now, what is the residential status of a student is living in India for studies? Because he will not fall under any of the three purposes. He will not fall under employment, he will not fall under business or vocation, he will not fall under that uncertain period criteria also. So there were some ambiguities. What is the residential status? because whether he is a resident or non-resident. If he is a resident, he cannot open a bank account outside India unless it is under LRS. So there are certain ambiguities, but RBI has given a circular, number 45 dated December 8, 2003, while taking up studies, the students may have to take up a job outside India or seek scholarship to supplement their income. As a result, their stay gets prolonged than what is intended while living in India. So they are not dependent for a dominant part of their expenses for remitting, expenses on remittances from their households in India. Hence, their stay will be for more than 180 days, and intention will also stay outside India for a certain period. They can be treated as NRI. So, as NRI, they can open a bank account outside India, and if they are coming back to India after completing their studies, they can still hold that bank account outside India, and that will be treated as a bank account open under LRS. So, Indian students studying abroad may maintain foreign currency account outside India during their stay outside India, and on return to India after completion of studies. Such an account will be deemed to have been opened under liberalized remittance scheme. Then there is one press release which mainly talks about the foreign national who comes to India for taking up business. Who comes to India for taking up business or employment. If you consider the definitions provided under FEMA, they will be person resident in India from the day come to India. From the day they come to India. So what happened is many foreign nationals started taking up, opening up a company in India, took up an employment visa, came to India, become a resident, bought a property, then leave India. So that's why the government has come with a press release for such foreign nationals only for buying property in India. Along with the intention, their number of days of stay also becomes relevant. So they have to stay in India for more than 182 days during the preceding financial year, and their intention is also to employment or business or vocation in India. Then they can purchase a property in India in the next financial year.
It's a financial year they can't buy.
They can't buy.
If, for example, a person who comes out first year, staying for more than 180.
Yes.
183rd day, he can't buy.
No. He can't.
Logical.
One has to verify the number of days of stay in the preceding financial year. Then buy a property in the next financial year. This financial year. Yes.
Then as the 183rd day should be valid.
But because the definition of residential status referring to the preceding financial year. Yes. Definition of NRI. NRI means individual resident outside India, who is a citizen of India. Then there is one more concept called resident but not permanently resident under FEMA. A person who is a resident in India on account of his employment or deputation for a specified period or for a specific job or assignment, the duration of which does not exceed 3 years, then they will be considered as a person resident but not permanently resident in India. Say for example, the foreign national, the cricket player who comes to India to play the IPL, they will be here for almost 3 months. So, what is their residential status? So, mainly for them, they may be treated as a resident but not permanently resident in India. If they are coming to India on account of his employment or deputation of a specific duration, a specific job or assignment, the duration does not exceed 3 years. Because for them, specifically for resident but not permanently resident in India, there are certain relaxations. That is, being their bank account can be resident. Such person who is not permanently resident may purchase foreign security out of his foreign currency resources outside India. Otherwise, he'll have to go under ODI route. But if it is out of his reserve, his savings outside India, he can purchase a foreign security outside India without going under the ODI route. Similarly, relaxed remittance facilities as stated above will also apply to citizen of a foreign state other than Pakistan, even to Indian citizen who is on a deputation to the office or branch or subsidiary or joint venture of a foreign company. Similarly, if he is a resident, then there is a cap of 2.5 lakh US dollar under LRS, Liberalised Remittance Scheme. But for them, there is no such cap. His salary, net of applicable taxes and applicable PF ESI, can be remitted without any limit. This is only for those people who comes to India on a deputation or a specific job or assignment. Mainly, this will be mainly in the case of multinational companies which has a subsidiary in India. Similarly, under Regulation 4, the possession and retention of foreign currency regulations, they can hold foreign currency notes in India without any limit if the same was acquired while the person was a non-resident. Otherwise, there is a limit of USD 2000. But for them, there is no limit. This is only for foreign currency notes. As an NPR, he can also remit his net salary abroad after payment of taxes, contribution to PF, ESI, without any limit. So, any confusion on residential status till now? We have covered the first part. Second and the third one. Yeah, we want to go on that. Second is my interpretation. So I'm going to discuss now. Third is, for person living in India, if he leaves India for any of the three purposes, he is not resident in India from the day one. If he leaves India for any of the other purposes, then he is a resident in India. Only if he stay in India exceeds 182 days during the preceding financial year. This is in line with the second interpretation. In second interpretation also, this is there. As we discussed, person going in outside India for medical treatment. Then we have to check what is his number of days previous year. The second part is for a person coming to India. If he comes to India for any of the three purposes, he becomes a resident from the day one. If he comes to India for any of the other purposes, then he is a resident in India only if he stay in India exceeds 182 days during the preceding financial year. That is for the foreigner who comes to India for medical treatment. His stay has exceeded for more than 182 days, and if his intention does not fall under any of the three purposes also. So whether we have to check 182 days. So third interpretation says you have to check his number of days of stay in India preceding financial year. So foreigner comes to India for a medical treatment in June 2024. He was there for till March, and his stay has exceeded 182 days in the current financial year. And in the next financial year, he will be a resident. He has to open a resident bank account. He has to follow the LRS route to remit money outside India. Second interpretation says, even if a person coming to India for any of the purposes other than the three purposes, then he is a non-resident irrespective of his number of days of stay in India in the preceding financial year. This says he is a resident in India if his number of days of stay exceeds more than 182 days in the preceding financial year. Previous years. So that says we don't have to look at the previous year if it is for other than three purposes. Yes. Any confusion? Can move on? The capital and current account transactions. See, the most and important aspects under FEMA is the capital and current account transactions. the whole framework of the depends on this capital and current account transaction. Therefore, it is important for us to understand the definition of the transactions and the what are the applicable regulations covered under the transactions. So for each type of transactions, we have to verify the definitions provided under the FEMA. What is the characteristics of the transactions, whether it is a capital account transactions or it is a current account transactions. Whether the transaction is allowed to be undertaken. If yes, whether general permission is there or specific permission is required, or whether it is with the condition or without conditions. So once you decide the residential status, then you come to whether the transaction is a capital account transaction or a current account transactions. The definition is provided under section 2. It says the capital account transactions means the transactions which alters the assets or liabilities, including contingent liabilities of outside India of a person resident in India. Similarly, the transaction which alters the assets and liabilities in India of a person resident outside India. So it uses the term alters. So alters means changing something which is already in existence. But considering the intention of the FEMA, even a creation of assets will be considered as an alter. So one has to verify what is, suppose if a person is gifting money to his relatives outside India, whether it is creating an asset outside India for him? No. Once the amount is gifted, nobody owns or owes anything to anyone. So it is a current account transactions. It's not a capital account transactions. Similarly, a company in India is importing a machinery. He'll import the machinery, he'll make the payment. Over. So nobody owes or owns anything. Under income tax, it is a capital, it's a fixed asset, it's a capital asset. But under FEMA, it is a current account transactions. Because it is not creating an assets or liabilities in India or outside India for a person resident in India, person resident outside India. So, what are the three important aspects? The residence of a person affecting the transaction, creation of or change in the value of asset or liabilities because of the transaction, and the place where, that's the most important, the place where the asset is held or situated or liability is incurred. So if you decide this residential status and whether it's a capital account transactions or current account transactions, then you can verify what is applicable to some regulations. Because if it is a current account transactions, it is permitted unless specifically prohibited. But if it is a capital account transaction, it is prohibited unless specifically permitted. That's why it is for one to verify what is the nature of the transactions, whether it's a capital account transactions or current account transactions. So this is the main principle under FEMA. Capital account transaction is prohibited unless specifically permitted. Current account transaction is permitted unless specifically prohibited. This is the applicable regulations. Sorry?
Creation of change in future.
No.
Because at present, yes, there is another creation.
At the time of executing the transaction.
Yes, it is created.
Yes, suppose if a person is buying a property outside India. So at the time of executing transaction, he is creating an asset outside India. It's a capital account transaction.
But in case of importing, we get the asset. Then, actually, this
At the time of transaction.
asset is getting coming into India. It is a current account because it is supposed to be paid, it is already paid.
Yes. See, for a person resident around India who is exporting machinery to India, it is not creating an asset or liability in India. He will export the machine, he will get the payment. Over. Similarly, for a person resident in India who is importing the machinery, he will import the machine, he will make the payment. That transaction will not create any asset or liability outside India for a person resident in India.
Within India.
Yes. So for a resident, you will have to check outside India. Similarly, for a resident outside India, you will have to check it creates an asset or liabilities in India. This is the regulations covering the capital account transactions. This regulation is also general in nature. It only says what are the permissible transactions. But if you want to verify the applicable rules and regulations, you'll have to check what is the applicable rules and regulations for that particular transactions. But there is a one regulation 4 which is important. That's why I covered there. No person resident outside India shall make investment in India in any form, in any company, partnership, firm or proprietary concern, an entity, whether incorporated or not, which is engaged in or proposed to engage in business of check fund, any company, agricultural plantation activity, real estate business, construction of a farmhouse, or trading in transportable development rights. So this is the where the investment is prohibited for a person resident only outside India for these sectors. However, there are certain relaxation given for a business of a chit fund. Suppose a chit fund company is subscribing its have subscription from a non-resident. The relaxation is given provided they take a approval from the state authorities who is regulating this chit fund. Similarly, real estate business has defined to exclude construction of residential commercial premises. It covers only trading in immovable properties, that is mere buying and selling. So non-resident cannot invest in a business which involves in trading in immovable property. But however, if it is involved in construction of residential or commercial premises, that is permitted under the FEMA. For the purpose of this regulation, real estate business shall not include development of township, construction of residential, commercial premises, roads and bridges, and real estate investment trust. Similarly, register of chits is already explained. He has to take the approval from the register of chits. So this is the permissible. There are two schedules. Schedule 1 for a person resident in India. As I said, Schedule 1 just gives what are the permissible transactions for a person resident in India. But if you want to check what is the applicable rules and regulation, then you have to refer the applicable relevant rules and regulations. If investment by a person resident in India in foreign securities, you will have to check FEMA overseas investment rules or FEMA overseas investment regulation, which is a notification dated 22nd August 2022. Similarly, foreign currency loans raised in India and abroad by a person resident in India, we will have to check the FEMA borrowing and lending regulations 2018. Buying or transfer of immovable property outside India by person resident in India, you will have to check FEMA overseas investment rules. Similarly, for different types of transactions, there is rules or regulations or notifications. Can we be shared? Yes, this will be shared. Similarly, Schedule 2. Investment in India by a non-resident, you will have to check FEMA non-debt instrument rules. Acquisition, transfer of immovable property, FEMA non-debt instrument rules. Import or export of currency notes, FEMA possession or retention of foreign currency regulations. So there are, depends on the types of the transactions, there is applicable rules and regulations. If a person wants to open a bank account in India, he has to consider the deposit regulations. Section 2J, it says, it talks about the current account transactions. It means transaction other than the capital account transaction. So for a particular transaction, you just check whether it will fit into the definition of a capital account transaction. If it will not fit into the definition of capital account transactions, then it is a current account transactions. And without prejudice to the generality of the foregoing provisions, such transaction includes, therefore, transactions which is covered under the current account transactions. Although it is payment due in connection with the foreign trade, other current business services, short-term banking credit facilities in the ordinary course of business. Here it uses without prejudice to the generality of the foregoing, such transaction includes. That means these transactions may fit into the definition of a capital account transactions. These it will still be considered as a current account transactions because these transactions are covered here. A person importing a machinery on a credit basis, it is creating a liability for him outside India. It is a capital account transactions, but that will be deemed as a current account transactions because it will fit here. Payment due in connection with the foreign trade or other current business or services. So it is permissible. There is the relevant rules 2000. There are 3 schedules. Schedule 1 talks about transactions which are prohibited. Schedule 2 talks about transactions with the prior approval of the government of India. Schedule 3, read with Rule 5, talks about which require prior approval of RBI if it exceeds the specified limit. So LRS, the Liberalized Remittances Scheme, is covered under the Schedule 3. Schedule 1, transactions which are prohibited, that is remittance out of lottery winning, remittance of income, racing, riding, or any other hobby, remittance of for purchase of lottery tickets. These mainly are a speculative nature. That's why the government has prohibited this transaction. A person cannot remit money out of lottery winning. Similarly, for purchase of lottery tickets outside India. These are prohibited current account transactions. Similarly, payment of commissions on export made towards equity investment in joint ventures, wholly owned subsidiaries abroad of Indian companies. That means to say, there are under ODI regulations, whatever export receivables is there, that can be capitalized by converting into equity. But payment of commissions against that export is prohibited. Remittance of dividend by any company to which requirement of dividends balancing is applicable, not effective at present. Commission on export, rupees trade, that is also not relevant now. Callback services is not at all there now. Remittance of interest from funds held in non-special rupee account scheme. This account also is discontinued now with the introduction of NRI account.
Only 8 is prohibited.
Which one?
Item 8. Why it is
Yeah.
prohibited? What is the
That
logic?
was there in the erstwhile in 2000.
That was in the FEMA.
Yes, not in FEMA regulations only, but this account is discontinued now. Non-resident special rupee account scheme. Now they have introduced NRI account, so it's not relevant. Similarly, transaction Schedule 2 transaction with prior approval of Government of India. There are certain transactions which requires prior approval of certain ministries, depending upon the type of the transactions. You may refer this schedule. Then we have Schedule 3, the Liberalized Remittance Scheme. Now many people have confusion whether Liberalized Remittance Scheme is applicable to non-resident. No, the Liberalized Remittance Scheme is applicable only for a resident individual, not for non-resident. For non-resident, there is a separate $1 million scheme. But for a resident individuals, not for resident companies or partnership firm. Only for resident individual, this Liberalized Remittance Scheme is covered, which allows a resident individual to remit up to $250,000 in a per financial year for all current account transactions and permissible capital account transactions. So, for current account, all the transactions are covered, but if it is capital account transactions, they have given only 4 types of transactions, which is permissible under the LRS route. Now, what are the current account transactions? This also is not relevant because they are given the clause 9 clauses, but in 9th clause they are given any other current account transactions. So all types of current account transactions, unless it is specifically prohibited, is permitted under Liberalized Remittance Scheme. Yes, it's specific number. Yes, yes. That also. The first 4 becomes relevant. Other now 4 are not relevant now, considering the amendment in the law. Private receipts, gifts or donations going abroad for employment, immigration, maintenance of close military abroad, travel for business, attending conference, expenses in connection with the medical treatment abroad, studies abroad, or any other current account transactions. Provided for the purposes mentioned in at item number 4, 6 and 4, 7 and 8, that is immigration, expenses in connection with the medical treatment abroad or any other current account transaction. The AD bank has the authority to allow remittances exceeding 2.5 lakhs USD, provided you give a sufficient documentary evidence. Suppose if it is for a medical treatment, you give a estimation from the hospital or a doctor. If it is for studies, you give a estimation from the universities. If you have a sufficient document, then the AD bank has the jurisdiction to approve these transactions. You don't have to go to RBI. But for all other purposes, you have to go to RBI if the remittances exceeds 2.5 lakh USD for financial year. And this 2.5 lakh USD per financial year for all the transactions covered under the liberalized remittance scheme. All current account transactions and capital account transactions. It is not per transaction. And it is obligation of a resident to see to it that it is not exceeding 2.5 lakh US dollar. Recently we had a case, the person has got notice from the bank itself. What he has done is, he has remitted funds under liberalized remittance scheme as a gift to his daughter. He has remitted around 2.45 lakhs USD. It is well within the limit. What he has done, then what he has done subsequently is, he has gone out of India, spent his debit card for paying hotel payment or whatever. It is also current account transaction. It is also within the LRS limit, and he has reached the LRS limit by 6,000 USD. Immediately in a month, he has got a notice from the bank, and bank has got intimation from the RBI saying that this one so person has exceeded the limit. You go for compounding. Then we had sufficient documents. Luckily, he had kept all the bills to which is matching to his transactions. He substantiated the transaction, and RBI has taken a lenient, and it has levied compounding fees depending upon the matrix given under the master directions on compounding. Otherwise, the RBI has the power. RBI officer has the power to levy penalty up to 3 times. So 6,000 USD means 18,000 USD. The compounding fees was charged. 50,000 plus 0.5% of the transactions involved in the confidential. So 0.5% of the 6,000 USD plus 50,000. So 50,000 is the minimum compounding fees. That's how with the advancement of technology, this transaction will got covered. Yes. Should have got. Actually, I shouldn't have allowed. They don't have the database, maybe. Yes. Within a month they got a notice. And they blocked his debit card as well.
Even if it's different bank also?
Yes. If you are executing a transaction under LRS, it has to be under same AD bank only. You can't. That's what the law says.
Actually, practically, people are changing the banks and doing, but actually RBI has mechanisms to cope up with that situation also. And this is one live example which we have got actually. Within a span of 3 months, the entire compounding of offences, everything was completed. He returned to India, within 1 month he got the notice. It is one village in Medicaid. There my friend actually referred me. I referred that case to him. So that's why I know about that case. So like that it is. That's right.
And these are the permissible capital account transactions. bank account outside India, purchase of property outside India, overseas direct investment or overseas portfolio investment. But the fourth one, extending loans, including loans in Indian rupees to NRIs. Loans in Indian rupees is covered, but loans in giving loan outside India, though it is covered here, it is not specifically covered under the ECB regulations, external commercial borrowing regulations. So that this loans outside India is not permissible. The resident cannot transfer or remit money outside India in the form of loan. But loan in India to his NRI account is permitted, provided there are certain conditions. Key points. Income earned need not be brought back to India. If a person is buying a property outside India under LRS, whatever rental income he earns, he need not brought back to India. He can make investment outside India. But there is one additional condition which is attached is the received, realized, unspent, unused foreign exchange, unless reinvested within a period of 180 days from the date of such receipt, shall be repatriated or surrendered to an authorized person. That means if he is receiving any income outside India, I mean he has remitted funds for purchase of a property, he sold that property, he has got that funds in his bank account, and if he has not invested that fund within 180 days outside India, he has to bring back the funds to India. Yeah, we don't know what is the reason behind this. This was not there earlier, and recently in 2022 or 23, this clause was introduced. Remittance under LRS cannot be out of borrowed funds for capital account transactions. That means one cannot borrow funds here, then remit money outside India for a capital account transactions. If it is current account transactions, it is permitted. So a person cannot take money from a bank and or from any person and purchase immovable property outside India. Individual will have to designate a branch of an AD through which all the remittances under the scheme will be made. So he has to designate a particular branch of a AD through which all the remittances under LRS should be made. Now, gifts in USD, there are two things here. Gifts in foreign currency, gifts in INR. Gifts in foreign currency can be made to any person. A person can remit money under LRS outside India in the form of gift to any person. It can be a relative or non-relative. But if it is in INR, that means if he is gifting that money to non-resident account, NRI account of a non-resident, then it has to be only to a relative. Difference is gifting foreign currency, any person, but gifting INR is only to a relative. And that has to be within the limit of LRS. So even if a person is gifting a money to non-resident account, NRI account of a person resident outside India, it still will be covered under the LRS limit. This limit, 100% is limit, but the difference is in foreign currency you can gift to any person, can be relative or not relative, but if it is gifted in INR, it has to only to a relative. Similarly, a resident cannot gift to another resident by remitting money outside India and LRS. I have a bank account outside India. You are also a resident, you have a bank account outside India. I cannot gift to you by remitting money outside India. That is a violation. And there is a compounding order on that as well. Here, one resident has remitted money under LRS in the form of gift to another resident who is bank account outside India. And RBI has got information as should have noticed. But he has brought back the funds, he has regularized the transaction, and what he can do is this one. He could go for the compounding. For compounding, first you have to regularize the transaction. The case I checked out before, he had brought back the funds, the excess funds remitted. What he has gifted to his daughter, he has asked his daughter to remit that for success fund to India. Then he could go for compounding.
And next year you can re-remit also.
Yeah, you can do that. Yeah.
How sale of property and realization of those sales and the OCI sends that money back from India to overseas?
That is covered under a $1 million scheme. It is not covered under LRS. LRS is only for resident individuals. For NRIs and OCIs, you will have to refer to $1 million scheme. There is general general provision which is that remittance out of sale of assets is permitted, subject to a limit of $1 million scheme. We are covering that in subsequent slides. So, resident, this is our third part. The resident individual can make rupee gift to NRI PIO, subject to the following condition: can be gifted only to a relative, that is relative defined under the Companies Act to the 2/77 by way of cross check or electronic transfer, should be credited to NRI account of the NRI PIO, and also should be within the overall limit of 2.5 lakh USD per financial year permitted under LRS for a resident individual. And it would be the responsibility of a resident donor to ensure that all the remittances made by the donor during the financial year, including the gift amount, have not exceeded the limit prescribed under LRS. So it is not bank's responsibility. It is the responsibility of the donor to ensure that this is within the LRS limit of 2.5 lakh USD. So he cannot say that, okay, I have remitted 2.4 lakhs USD under LRS, then I will remit the balance funds under to NRI account. He has to verify both. This plus this should be within the 2.5 lakh USD. Any confusion? Now, facility to grant loan in rupees to NRI PIO close relative. A resident can give loan to NRI PIO relative subject to the following condition: the loan is free of interest and the minimum maturity of the loan is 1 year. That means NRI cannot repay the loan within 1 year. And definitely many would have not complied with this. If a resident is giving loan to the NRI, to his NRI account, that loan should not be repaid entirely within a period of 1 year. And it should be free of interest. He cannot charge interest. Within the overall limit of USD 2.5 lakh, including all the remittances. No.
Even he is ready to pay. We cannot take credit. I mean, it is risky.
But if it is under the LRS, then the income tax rule will come and also TDS
Income tax.
TDS will be applicable then if it is under the LRS.
No, sir. And there is a catch on that there also. If it is to NRI account, especially.
Then under the LRS.
It is within the LRS limit.
Sir, don't ever mix any particular transaction. Don't ever mix income tax provision and FEMA provision. That has to be seen independently. Now, when it comes to applicability of TCS, you are talking about TCS applicability 20% or 5%, 0.5%, whatever it is. Now, under LRS, what saying is when a remittance, when there is a purchase of a foreign currency to be remitted outside of India under an LRS, at that time there is a requirement of doing TCS. Okay, but if there is a remittance to a non-resident's NRO account, it is covered under LRS, no doubt. But there is no purchase of a foreign currency for the purpose of such transaction.
But in such case, HRS means we have to go through this authorized banker.
No, actually, it is since it is a permitted transaction under LRS up to 2.5 lakh USD, you can remit it to NR account without any requirement of permission.
Okay.
But if you are purchasing a foreign currency for remittance outside of India under an LRS, at that time only TCS is required. Even bankers are defaulting on that, they are correcting TCS for remittance of funds to an NR account. That is incorrect. And we have corrected the banker in several cases. We are able to. Some bankers, of course, they are not able to cope with this.
But in such case, they should not get that HRS form. Automatically, they have to do it by way of online or by a cross check. Then they will not come to know.
And that's it.
Like the coffee time I will ask how this 6,000 they got it from.
Even that remittance from EFC account also. EEFC account. Yeah. Exchange of foreign currency account. The law says the TCS is applicable for purchase of foreign currency and LRS, but EFC account is not purchasing in foreign currency. It is only out of his reserve he is remitting funds. Though it is covered under LRS, TCS is not applicable.
Because you already have a foreign currency. Out of that you are remitting. In this case also we are able to convince the bank.
The ICICI Bank, initially they were like, no, TCS is applicable, and the client is like, we have told the client, TCS is not applicable, but when he, at the time of executing transaction, when the bankers were telling them, no, TCS is applicable, we had to give the opinion in writing. And that has verified by their central branch also, and they could execute the transactions without the applicability of LRS. TCS, sorry. For the loans, these are the conditions. Shall be credited to NRI account. It shall not be remitted or repatriated outside India. Repayment of the loan shall be made by inward remittances or to NRI account or NRE account, or is of the borrower out of the sale proceeds of the shared securities or immovable property against which such loan was granted. Purchase of immovable property outside India, as I said, this transaction is also covered under LRS. This is purchase of immovable property outside India by the resident. It's covered under the LRS, subject to a limit of 2.5 lakh $. Earlier there was, for immovable property, there was a condition that suppose if the property value is 5 lakhs. So both husband and wife are resident here. So if what happens is both husband and wife could consolidate both 2.5 lakh $, and remit funds under LRS and buy the property outside India. But there is one more condition attached to it, that the who is remitting, that the wife, should also be the co-owner of the property. Otherwise, she would not remit money under an LRS. But in 2023, this condition was removed, and actually nobody was aware of it. Even the banker was not aware of this. Bankers were not aware of it, and yes, so if a property of high value is there outside India, both husband and wife can consolidate the limit and buy property in one person's name.
I feel that it is because of issuance of golden visa in UAE that has triggered this amendment, where they allowed only to for the husband to purchase the property, even the wife can remit. Up to $5 million they can remit, up to $0.5 million they can remit in a year, husband and wife together. But still, husband can purchase the property on his own name. So that he will be able to get a golden visa in UAE. That is like a PR. So I think once that came into existence, somebody having the power influenced it and corrected this rule.
But there is a catch also there. And also wife should also have a golden visa. But that is again problem.
That is on dependent visa they will get golden visa.
That dependent visa they give it. There is one case also that dependent visa that wife name is not with them. That is for some reason. beyond control.
There is a schedule 1, 2, 3. Schedule 1 is strictly prohibited under Triangle Transaction Rule. But for schedule 2 and 3, if it is remittance out of the RFC account, that is, and EFC account, this rule 4 and rule 5 will not apply, subject to certain exceptions given under the rules. Similarly, use of international credit card while outside India when he was on a tour or a visit, this LRS limit is not applicable.
Can you speak only this? There is not applicable for use of credit card.
International credit card, when he was on a tour outside India, if he is using while in India for purchase of any Amazon or through Amazon or anything, this is applicable. But if he is on a tour outside India and he is using his international credit card, then this LRS limit is not applicable. What is the consequence of violation? Penalty up to 3 times the amount involved in the contravention. If the amount exceeds 1 crore, then the seizure of equivalent assets in India under section 37A, and this is not compoundable offence. Means if a person is violating this section, if he has bought any asset outside in contravention of FEMA regulation, it is covered under section 37A, and the regulator, the enforcement authorities have the authority to seize the equivalent value of asset in India. He cannot go for compounding also. He has to pay the 3 times penalty, bring back the funds, can also lead to prosecution. So overall scheme of FEMA, we already covered all the current account transactions not listed in any of the schedule 3 schedules. The FEMA is freely permitted unless specifically prohibited or restricted in other regulations. All the capital account transactions are prohibited unless specifically permitted. We will cover section 3 after the T. We have section 3, then purchase of property in India, then remittance of funds. Okay, we will be able to cover next 45 minutes. Same as otherwise provided in this Act, rules or regulations made in India, or with the general or special permission of the Reserve Bank. That means, if a transaction, unless specifically permitted under the rules, regulations, or made there or the Act also, no person shall deal in or transfer any foreign exchange, foreign security to any person not being an authorized person. So you'll understand better with the help of example. A person, I am a non-resident, I come to India, I have 200 USD, you offer me better rate, you can give me somewhat 200 USD and offer you better rate than the bank, and I am agree to it. Whether this is permissible? No, it is not permissible. Whatever deal or transfer of foreign exchange or foreign security happens, it has to be done through authorized person only. Sell to institute country who is a resident in India, offers him a better rate. Can he sell? No, it is violated. Section 3B. Definitely we would have violated this. No person, so whether he is a resident or non-resident, no person shall make any payment to or for the credit of any person resident outside India in any manner. Say for example, A is an NRI, his brother Mr. B is a person resident in India. Mr. A has to pay to Mr. B, who is a resident in India, for buying a movable property in India. What he will do is Mr. A will ask Mr. C to make the payment to Mr. B.
There's always happens. Be it an iPhone or
Yes.
whatever it is, you $5 as it's saying.
Yes. So what happens is A is an NRI, B is a buyer, B is a seller. Seller is a resident in India. A, what he will do is, instead of remitting funds from outside India or utilizing funds in the NRI account, what he will do is, he will ask Mr. C, see, this is there, you pay the consideration, Yeah. Or
You had the
that is covered under clause D. I like also cover that. But can you make the payment? I can't make the payment.
This is commonly made.
I'm saying that's what I'm saying. Many have provided this.
Mr. D is in the hospital, upper hospital. A calls also, pay this much, no problem. Okay.
So understand. And there was
Upper hospital means whatever I say, they will do, you may everything. Then I pay to the upper hospital.
No, but can government ever control this?
during FEMA regime they were controlling this.
Oh.
Now since the country has don't know sir, but I got to read many case law which is of FEMA regime. But similar provisions is there in the FEMA regime also. Now since the country has having sufficient forex, they are not much worried about it, but we don't know about the future.
Right. The FEMA thing, whenever you are coming here, whenever you land here, mother gives for something buffet or some sweet is also not allowed.
It is not allowed. See?
Because that money would have been remitted to your mother and the money is available to give. How is it possible? Your son is coming all the way from there. Okay.
There was one decision, sir, where a resident has paid the electricity bill on behalf of another resident. And penalty was levied. No, that is compounding. This is 3 times. No. That is 50,000 was a compounding fees. Minimum. Lenient. Theoretically lenient. We will not levy the 3 tax. But it is.
Property tax you will be paying it.
Yeah.
On behalf of NRI.
There is a decision on that.
NRI property is there.
Yes, it was covered. Electricity bill, property tax, medical bill.
The main thing is the medical property tax.
So if you take the legal interpretation, if your brother or sister who is an NRI who comes with the family here, you take him to the restaurant, you pay the bill, that is also violation.
Yeah, you take him all the way to Bangalore and other things. Also violation. At the end he will give another violation of the first one. He will give 2,000. If we go to the market and sell. The third violation.
But there are certain exceptions given under this regulation, that is Foreign Exchange Management, manner of receipt and payment regulation. That's why I said you have to cross-link. You have to link the notifications, regulations, so then come to a conclusion. That's why the FEMA is not drafted friendly manner. So as per this regulation, a person resident in India can make payment in rupees towards meeting expenses on account of boarding, lodging and services related, only these services, boarding, lodging and incidental services related thereto, or travel to or from or within India of a person resident outside India who is on a visit to India. But for food, it is not covered under the exception, is still a violation. A company or a resident in India may make payment in rupees to its non-full-time director who is a resident outside India. This is for a non-resident director who is coming to India for a company's work and is entitled to payment of sitting fees or commission or remuneration and travel expenses to and from and within India in accordance with the provisions contained in the company's memorandum of association or articles of associations or an agreement entered into by it. It will not be covered under the section 3B. The company can pay expenses. Basically, the company can pay expenses of a non-resident director who is on a visit to India, provided it is permitted. It is clearly provided under the MOA or AOE of the company. Then we have section 3C. No person shall receive otherwise than through authorized person any payment by order or on behalf of any person resident outside India in any manner. Example, Mr. A is an NRI, his brother is Mr. B, he is a person resident in India. Mr. A wants to sell his land in India to Mr. B. It has to be Mr. B, who is a resident in India. Mr. A appoints Mr. C as his power of attorney and ask Mr. C to receive the same consideration from Mr. B, Mr. B will make the payment to Mr. B on the section of Mr. A. So, can I do so? The answer is no. Here, both sections are violated. Section 3B. Section 3B is violated by Mr. B, who is making payment to Mr. C, not to Mr. A. And Mr. C has violated section 3C to receiving the payment on behalf of Mr. A. This has commonly happened. Who is given power of attorney? Yeah.
So Indira can never give a power of attorney to anyone.
They can give a power of attorney, but they cannot give for executing the transaction. But that power of attorney holder cannot receive the same consideration.
Oh.
Yes, yes.
It has to go to the non-resident bank account.
But the thing is, the money will be going, only thing is the transfer fees and the execution fees are paid by this
C.
Again,
It's a violation.
violation.
He is paying on behalf of
Which
non-resident.
can be said by, okay, then subsequently reimbursed by him subsequently, then also violation.
Violation.
Because the
So,
money has
violation-
gone first.
So first take and then give.
Yes, it's always better. First take and then give.
Not possible.
Even CS, in fact, one of the CPS in CS has violated this. CS who has done the property transaction of a non-resident, he has
But
paid
it's not
the
possible to
registration
separate
fee.
this. At the registration office, they will say, there is a shortage, is there, you have to pay this. Not possible. Not possible.
It's nothing like not possible, but it is that because of shortage of time, etc. That tends to, finish up. Okay, I have got. Is my friend is going to pay me anyway? This is what.
And also Mr. A will say, you have the power of attorney. You have the power to buy and power to sell also on my behalf. You have to do it. You have to do it. Mr. A will say.
Any power of attorney or any agreement or something cannot be beyond law. Any law for that. That's the
We
Apart from that, there is TDS also on this. Ideally, yes, for the TDS and this.
So there is a case law, Murgas Moses, Director of Enforcement, which is in contravention of Section 9, Clause 1B, which is Section 3C, 910 of B of FEMA, which is Section 3C of FEMA, was confirmed by the FEMA board against the appellant who received the rent and other monies on behalf of a non-resident. The appellant transferred the money received by him to the wife of a non-resident. On these facts, the appellant was held guilty of contravention of Section 9(1)(b). Here, what has happened is the resident has received rent amount on behalf of a non-resident. Even that was held as a violation. Section 9(1)(b), which is Section 3C. 9(1)(b) of FEMA, which is Section 3C of FEMA.
It was strict at that time.
It was now, but we don't know.
No case now.
No. But we don't know about the future.
So we can't create a case law for ourselves.
Now we have Section 3D that says no person shall enter into any financial transactions in India as consideration for or in association with the acquisition or creation or transfer of right to acquire any asset outside India by any person. This is basically Hawala transaction. I will pay you, you will ask your relative or friend to pay to someone outside India.
What's that thing?
So that is covered by Section 3D. It's a violation. So Mr. is a resident in India, Mr. B is a NRI, is a brother of Mr. A. A will give INR to Mr. C, he is a resident in India. For this transaction, Mr. B is in Dubai, he will get the equivalent amount of USD from Mr. D. So all transactions cannot be undertaken. Now we have Immigrating Indians. Immigrating Indians. What are the obligations for immigrating Indians? Because when they leave India, they have their investments, they have their bank accounts in India. What has to be kept in mind? We will be covering that. So, Section 6, as I said, this is a general provision. It says that a person resident outside India may hold, own, transfer, or invest in Indian currency, security or immovable property situated in India, if such currency, security or property was acquired, held, owned by such person and he was a resident in India or inherited from a person resident in India. But the main catch is if the transaction covers only Indian currency, security and any immovable property. What about jewelry? That was not covered. But assets even is covered. The same can be transferred or reinvested. The non-resident can inherit the same from a resident. But the other assets is not covered under section 6.5. The RBI is not aware when he has drafted the section 6.5. But subsequently, when many of these CE Institute brought to the notice of the RBI, it has given a clarifications that yes, the other assets also covered under section 6.5. So if a non-resident has a jewelry when it was purchased when he was resident, that same can be held. Whether other assets like jewelry, painting, silver articles, interest in the LLP partnership can also be in terms of section 6.5. Yes, it is covered under section 6.5. Now, what about interest in LLP or partnership firm? I was a resident here, I was a partner here, and in LLP or partnership firm, I was a director in company. Now I move out of India, I become a non-resident. Whether I continue to be a partner here? Yes, as per section 6.5, it is covered. Intention of section 6.5 to permit the NRIs to own all assets which he was owning prior to turning to NRI. NRI can continue to even as a partner of an Indian LLP even after becoming NRI. Fresh investments in the LLP towards capital may be made through NRI account. To make it distinctively clear that fresh investment is also non-repatriation basis. Because what happens is his investment which was made when he was a resident will be categorized as a non-repatriable investment. So even the fresh investment should also be categorized as a non-repatriable investment. So for that he has to make the fresh investment should be from the NRI account. Whether can he give the loan? That's the question.
I think yes, that some previous section.
Section 6.5. Section 6.5 says the investments undertaken when he was a resident here. But what happens? Now he moved out of India, becomes a non-resident.
But he became a partner here before.
Yes,
so
but this subsequent loan is not undertaken at the time of resident. If it is if it is made at the time of resident when he was a resident, that can be continued, but fresh loan cannot be given because LLP is not eligible to take loan from the partners. But there is also another interpretation which says that if it is out of the NRI account, which is from the domestic earnings, then the loan can be given and that will not come under the purview of FEMA. Any professionals will take this interpretation as well. But from NRI account, definitely cannot give.
No clarification from RBI.
No clarifications. Existing loan to LLP may be continued. However, repayment of loan by the LLP or firm shall be made to NRI account. Bank account is resident bank account should be redesignated to NRI account. It's very important because what happens is if imagine he has not converted his bank account to non-resident account and he makes investment in India by a property or he makes investment in shares, it's a violation. And the RBI can levy a penalty up to 3 times. So that's why he has to redesignate his bank account to NRI account, and he may also open NRI account to receive the inward remittances from outside India. And inward remittance can be invested in the foreign currency non-resident account in the form of deposits in freely convertible foreign currencies. FCNR can be in the form of term deposit also. Bank will not agree. Bank will say you have violated. Bank will not agree their fault.
We have some communications and documents.
Documented.
That's what I asked. Like, when you email the thing, they are saying what.
What is the point when you pick it?
Earlier the shares were there. Now became an NRI. They continue to invest in shares. It was not a bank account was not I think even that
Demat account.
They had two accounts. They created one new one. But here also shares are stuck.
That has to be transport actually and not demat account. You cannot keep the resident demat account.
So, for this first point, how many other bank accounts you have? Everything should be made as
Yes, you cannot even keep the resident account at all. Even FD also. Bank will say that you keep till maturity, then will convert.
What about this lockers and all that?
Also not. Yeah.
NRO, then you
Yes.
NRO.
No,
No, actually, here you are saying it should be changed as NRO account and like that. But the thing is, you will come to know I am a resident or not resident after completion of that financial year.
If you are leaving India for employment,
Automatically you will become under FEMA, you
you
become
don't understand. You don't confuse with income tax act. Under FEMA, you are that's why I am saying. Under FEMA, it is not a particular date. If you have to wait till 31st March to know whether you are resident or non-resident. It's not.
Can they go for only notice?
What happens? You wait. I mean, it's already now redesignated. Still under resident.
Still there, that's what.
Immediately you redesignate. If anything comes up, you say that we have communicated this, but you don't have any documents.
At least from my experience, what I can say is, okay, now there is a violation. Which is continuing. Stop it somewhere.
Yeah.
First, you stop it somewhere. So your period of violation is restricted. So the penalty for which we can levy also would get restricted to that period.
No, penalty irrespective of the period 3 times. But if you go for compounding,
Yeah.
they will see what is the period of contravention. Depending upon that, they will levy the compounding fees. And they will also, can convince that, you have regularized this once you come to know that you have violated this law.
Penalty is 3 times. Compounding is additionally
No, penalty is 3 times. To avoid penalty of 3 times, you go for compounding.
How much would this be?
It depends upon the compounding fee matrix. It depends upon the nature for different types of violation. Different type of compounding matrix is there. So, in my view, 50,000 is the minimum. But depend upon the period of contravention, that 0.5%. If it takes it's 1 year, up to 2 years, 0.75%. Subject. But they have the discretionary power to. It's a discretionary. It's not mandatory. They have the power to. Oh no, you have done this intentionally. 3 times penalty.
Then 3 times of what?
Waive also?
details of levy.
What? Yeah, discretionary.
Waive the penalty also?
Yes. If they feel that this is done intentionally, they may levy penalty up to 3 times.
And 3
There is one compounding decisions where RBI has levied penalty of 3 times for buying agricultural property. Its compounding fees is levied of 3 times. NRI buying agricultural property in India. Whereas in other cases, they have taken a lenient view and levied compounding fees based on the compounding matrix. Then the value of the property was 15 lakhs, you have to pay 45 lakhs. And
Assessment.
share the demand is.
Assessment. You go and across the table.
It's the one disadvantage is you cannot appeal against the compounding order. So before going for compounding, you have to think twice.
This 3 times of what? The balance on
Amount involved in the contravention.
Contravention means what is the balance? It was a balance
Yes.
for transaction or total or something.
Balance.
Maybe different. For example, let me add this. Now, if it is a resident account, which one is maintained, he has already deposited some money, he has withdrawn some money. So, it may be, for different periods, the amount involved is different. So, they may look into all that and then, calculate the result. So, it might be very high.
In one case, what has happened is, person was not resident. He came back to India. He had the FCNR account. As per the law, you can keep the FCNR account till maturity. But upon maturity, either convert to resident account or keep the RFC account. What he has done is, he has still continued that FCNR account for many years. And the period of contribution also around 15 to 20 years. The penalty was also not penalty, he has got for compounding, but compounding fees also. The RBI has taken whatever the excess money, income, what he has earned in the form of compounding fees. It was in crores. The RBI has compared, had it been compared, kept in a resident account, what is his interest and what is his interest in a FCNR account. They compare the difference between the two.
So, if found, or should I go for compounding? If it is not found, then better to sell it off and then close it.
We normally tell the client it's up to you. Compounding is voluntary, always voluntary. Even if you receive a notice from your AD banker, still it is voluntary. Even if you don't receive, then also it's voluntary. You can go on your own. So, under those cases, we tell the client, you want to become free, go for compounding. If you want to take a chance, keep quiet. If at all a first notice comes, then approach us so that we can, try to settle this matter in compounding.
In that debit card
matters.
Intention matters. Yes.
Yeah.
What you want to do.
See, in that debit card case also, he has got notice from the bank, not from the enforcement authority. Who is enforcement authority? ED. But he wanted to become a claim.
Because it's from RBI to
No, yes.
Yes. ED, whether it makes a difference.
Yes, ED will investigate. ED will. But at that most he can go for compounding. At that most he can go for compounding. First ED will investigate, then it will file a complaint with the adjudicating authority. Then the adjudicating authority will issue the show cause notice. So funds in the NRI account, FCNR account is freely repatriable, whereas repatriation of funds in the NRI account is subject to USD 1 million. Joint account in the name of two or more non-resident individual is permitted, provided all the account holders are a person of Indian nationality or origin. Joint account with the resident relative also permitted. In respect of NRI or FCNR account, the resident close relative shall be eligible to operate the accounts as a power of attorney holder in accordance with the instruction of NRI. Demat account, section 6.5 permits, so but the resident demat account has to be converted to NRI demat account. He cannot give the resident demat account. And if he wants to invest on a repatriable basis, he has to open NRI demat account. And he has to have a separate NRI bank account for that. So that whatever investment also goes from that account and the sale proceeds also will get credited to that account. And that 1 million USD is not applicable for repatriation from the NRI account. It is without any limit. But if it is from an NRI account, the 1 million USD is applicable. NRI needs to implement the depository about the change in the registration status. Impact on transaction done at the time of when he was a resident is covered, or the investment in securities existing on the date of becoming NRI will be characterized as a non-repatriable investment. Designate to NRO demat account from resident demat account, NRO demat account non-repatriable basis, but still you can take shelter under 1 million USD. NRO demat account repatriable basis. Which one? The NRO demat account. See, NRO demat account basically not repatriable, investment is on a non-repatriable basis, but you can still take shelter under 1 million USD. it talks about the remittance of assets. You can remit up to $1 million.
It's all in that same pool.
Yes, it's all in the same pool. Along with the other, this transaction, other transactions is also covered. But if it is a NRI demand account, without limit. But you must have separate NRO and NRI bank account for this PSP demand account. Insurance policy also can be continued to be held. TPF account also has got so and so notification dated 23rd February 2018, and NRI can continue to operate the TPF account and continue to invest till it matures. After maturity, they can invest. If it is open when he was a resident, if it is open when he was a resident, he can continue till he can invest.
Invest. You have to invest every year. Okay. Public means you have to minimum that amount we have to invest. 1,500 or 15,000.
So foreign currency.
It is possible because otherwise TPF accounts gets freezed.
Every year.
Minimum one investment, minimum some amount. They have to put. So that's the case. If a resident opened a TPF account and then became a non-resident, he can continue to deposit. Of course, up to maximum of 1.5 lakh per the rules of TPF. But they can, it gets matured on 15 years. As soon as that, you can continue.
So all foreign currency investment made under LRS when he was resident can be continued to be held. In case of ODI transactions, what happens is a person resident has made investment under ODI. Under ODI, he has certain obligations, file APR forms, report to the bank. But if he becomes a non-resident subsequently, he can file ODI Part 3 to cancel his UIN number and also provide sufficient documentary evidences to prove that he is a non-resident and cancel this UIN number, unique identification number, and so that he did not file his APRs forms for the subsequent years. But he has to file for the year in which the investment was made. Investment in immovable property can be continued. Now we will cover the returning NRIs, which is covered by section 6.4. It also talks about, it is similar to section 6.5. The investment made when he was a non-resident can be continued to be held. Under FEMA, he had to sell all the investment and bring the proceeds to India when he becomes a resident here. But under FEMA, he can continue that investment which was made when he was a resident outside India. So those coming to India for a permanent settlement, they can keep their bank account, they can keep their shares, property, they can sell it, whatever investments, further investments can be made. Foreign currency account opened and maintained by such person outside India, and he was outside India can be continued to be held. Even income earned through employment or business or occasion outside India, which was taken up or commenced when such person was resident outside India, or from investment made while such person was resident outside India, can also be continued to be held outside India. He did not bring those funds to India. If it is that employment or business or occasions or investment was made when he was a resident outside India. Say for example, a person has made investment in shares and he was resident outside India. Now he comes back to India, he has got dividend. He did not repatriate that dividend to India. He can further reinvest that dividend outside India.
Where is the 180 income from investment has to be?
That is for investment made under LRS, Liberalised remittance scheme. Not this. This is returning NRIs.
So for this,
No. No, she was saying that under LRS, if you have funds in a bank account, say you have made investment under LRS, you sell those shares and you have the funds in your bank account and you have 180 days time to make further investment. If you don't make any further investment, even if you keep it on deposit, you have to bring back the funds. You have to make it further in any further. You have to make investment. Ultimately. You cannot keep those funds in the bank account. But for this year, for returning NRIs, thus that condition is not applicable.
Income was earned, then he was a
Non-resident. Even investment also made was when he was a non-resident. So it's not applicable. Eligible assets abroad as well as income of such assets also proceeds thereof received after their return to India for making any payment or to make any fresh investment abroad without the approval of Reserve Bank, provided the cost of such investment and the subsequent payment received thereof are met exclusively out of the funds forming part of the eligible assets held by them, and the transaction is not contradiction with the extent FEMA provision. So he cannot utilize the funds to buy a lottery ticket because that is strictly prohibited under Schedule 1 of Current Account Transaction Rules. This is also covered, other assets also covered jewelry, interest in LLP partnership form. ODA, FTA structure, an individual who was having a company outside India while he was being a non-resident, upon return to India, he can continue such investment. He did not make any reporting to the banker unless he makes a fresh investment.
I have a doubt. See, this bank accounts, suppose we have a joint account, and one of the members is becoming NRI, leaving India.
Okay.
Okay, so what would happen in that case?
You're saying
I have a bank account.
joint account, both of them are residents here. They have
Yeah, so
residence.
suppose I have a joint account with my parent
Okay.
and myself.
You
So
can
I'm
only
going to-
continue as a farmer on survival basis.
That will not be a
No. Non-resident can be a joint account holder in a resident account on a farmer or survival basis.
You are a survivor.
Yeah.
What happens in partnership then? Partnership also will be a joint account.
But it's in the name of a firm. No?
Oh.
In that case, the joint account, he cannot be the first party.
No. You cannot be the first party.
Otherwise, it will become a
Yeah.
change.
No, either if he wants to continue as joint account holder, he has to continue as a farmer on survival basis. He has to intimate to the bank
Yeah,
about
either
his residential status and all the procedures to be done.
Then if the farmer becomes NRI, I mean non-resident, then it has to be converted.
Into a
Yes. Bank account, foreign bank accounts can be continued to be held. NRI account should be redesignated to resident account immediately upon return to India. Many people will violate this because the banker will say that NRI account, if you have a FD account, you keep till the maturity. Then you convert it. No, the law does not provide for such thing, and you have to convert it immediately to resident account. Or alternatively, you can keep it in RFC account, resident foreign currency account, if you want to retain the repatriability nature of the funds. I mean, if you feel that no, I need these funds for any future obligations which is outside India, you can still keep that funds in the RFC account.
This RFC account, how many years can be?
Depends on the banker. You can renew it.
But it is a fixed deposit then.
It's a fixed deposit.
Since some of the people, they buy property in Singapore, they have to pay taxes. So they keep it in the RFC so that
Yes.
things get.
Funds in the NRI account can even be transferred to RFC account at the option of the account holder. NRI account should be redesignated to resident rupee account. FCNR deposits can be continued only till maturity. On maturity, it can be converted to rupee deposit account or RFC account.
That RFC will be more or less will be from the
FCNR, yes.
But the only because interest is taxable for the income tax.
I will cover.
Oh, okay. Sorry.
Then we have insurance policies which is taken up outside India can be continued to be held. No permission required for payment of the premium, but maturity proceeds or amount of any claim due shall be repatriated to India within 180 days. RIC account, we have already covered this. If you permit, I can skip this. Now, remittance facilities for NRIs, PIs, and foreign exchange management, remittance of assets regulations 2016, notification number 13R 2016. Here, it has different types of regulation for foreign national as well as for NRIs and OCIs. So, we will be covering what is the regulation for NRIs and OCIs. Remittance of assets means remittance outside India of funds representing a deposit with a bank or a firm or a company. Probability of balance or superannuation benefit, amount of claim eligibility, proceeds of insurance policy, sale proceeds of shares, securities in immovable property, so and so. So here it has given just the term immovable property. Subsequently also, it says NRI PIO may remit an amount up to $1 million per financial year out of the balance held in the NRI account of sale proceeds of assets on production of documentary evidences in support of acquisitions in evidence of legacy of assets. And even the sum received under deed of settlement made by either of his parents or relatives and settlement taking effect on the death of the settler on production of original deed of settlement, remittance of all installments shall be made through the same authorized dealer. It generally says that NRIs and OCIs can remit up to $1 million per financial year for capital account transactions, on account of capital account transactions. And there is no limit on the number of properties that can be sold.
So whether it is property or provident fund
Or
everything
shares,
happens at the
everything
same
is
year,
same.
still it's only 1 million.
1 million, yes.
What if there's no chance to limit more than that?
You have to go to RBI. RBI will see the facts. If they are convinced that you have genuine difficulties or if you don't execute these transactions, then they will allow you to. But that's very likely to get approval. So this is a specific provisions which covers the remittance of funds. And best part is this limit of $1 million is not applicable for current income. Say for example, you have investment in shares which is made on a non-repatriable basis. If you are selling the shares and repatriating the funds, then you have this $1 million cap. But if it is a dividend income, which is in the current income, you don't have this limit of $1 million. You can remit up to any amount. And recently we are able to convince the one banker, which is up to 100 crores, a dividend 100 crores. The transaction is not happened, but we are able to convince the banker this limit is not applicable for the current income. So rental income, dividend income is not subjected to $1 million. NRI is covered. CA certificate 15CB undertaking by the remitter in 15CA. If it is exceeding $1 million per financial year with the RBI prior permission on the grounds of hardship or PRIO. If remittance is from India is not made, subject to imposition of terms and conditions deemed necessary by RBI. Okay, now acquisition of immovable property in India by NRI or OCI. For this, one has to refer the non-debt instrument rules. So there are three modes of acquisition. One is acquisition by way of purchase, acquisition by way of gift, acquisition by way of inheritance. So just put up in a tabular presentation for better understanding. If it is by way of purchase, other than agricultural land, farmhouse, plantation property, he can purchase from a resident NRI or OCI. If it is by way of gift, he can acquire only from a resident NRI OCI relatives as defined in the Companies Act 2013. So for both, he cannot acquire the agricultural land or plantation property or farmhouse. Either it can be by way of purchase or by way of gift. But if it is by way of inheritance, he can buy any property. Agricultural, non-agricultural, there are no restrictions. But the catch is, if it is inheritance from a person resident outside India, the purchase should have been made by such non-resident in accordance with the FEMA law. If we had purchased property which is not in accordance with the FEMA law, then this inheritance is a non-compliance. Or from a resident. Payment for acquisition of immovable property, funds received in India through banking channel by way of inward remittance from any place outside India, from NRE, FCNR account or NRI account. No payment for any transfer of immovable property shall be made either by travelers checks or any foreign currency notes or by any other mode other than those specifically permitted. So what is specifically permitted? Only these two, that is inward remittance or from NR or NRA account. Can he pay in cash? He can't.
What if he withdraws from his NRI and still not allowed?
Not. The problem is how do you prove that it is out of the withdrawal from the NRI and NRA account? Yes, personal will still there, then you paid cash. How can you correlate it? Transfer by way of sell other than agricultural land, plantation, property or farmhouse to resident NR and OCA. If you are selling agricultural land, farmhouse, plantation, property, you can sell only to residents. If it is by way of gift, again, if it is other than agricultural land, farmhouse, plantation, property, it can be gifted to resident NRI, OCA relatives. Other than, if it is agricultural land, only to resident relative. Prohibition on acquisition of transfer of property in India by citizens of certain countries, that is the neighboring countries. This person who is a citizen of these neighboring countries are prohibited from purchasing a property without the permission of the Reserve Bank of India. Which are the countries? Pakistan, Bangladesh, or land border sharing countries, Afghanistan, China, Iran, Nepal, Bhutan, Hong Kong, Macau and Republic of Korea. Provided that this prohibition shall not apply to an OCA. That means if that person is an OCA card holder, then he can purchase the property. Otherwise, he can't. So, citizen of these countries who comes to India for employment or any business obligation, they can't purchase the property without the approval of the RBI. You have to go to RBI. Yes.
Eligible to be an OCA, we tell them first get an OCA card. So you become OCA. And then correct way. But then we tell them take it.
As an OCA, they can do only. Not that difficult, but yeah, still you have to go to RBI. You know how the government officers are. Yes. Joint acquisition by the spouse of the NRI OCA, that is, the NRI OCA, if he has married foreign national, and foreign national can purchase a property in India jointly with that NRI OCA spouse, subject to the conditions given here. The consideration for the purchase shall be made out of the funds received in India or NR or NRI account. No payment for any transfer, again same, it shall not be made other than those specifically permitted under this clause. The marriage has been registered and subsisted for a continuous period of not less than 2 years. Immediately preceding the acquisition of such property. The non-resident spouse is not otherwise prohibited from such acquisition. That means a non-resident spouse should not be citizen of those land border sharing countries. Yeah, cannot be done directly, cannot be done indirectly. So, repatriation of sale proceeds, sale of immovable property other than agricultural land, farmhouse, plantation property in India by an NRI OCA. The authorized dealer may allow the repatriation of the sale proceeds outside India provided the following conditions are satisfied, namely, the immovable property was acquired by the seller in accordance with the provisions of the foreign law in force at the time of acquisitions. So the purchase should be made in accordance with the FEMA law, then only you can repatriate the funds. Otherwise, you have to go to RBI.
Interesting point which we came to know. FEMA came into existence with first May 2000.
2000.
Okay, prior to that, FERA was in existence. Now under FEMA, acquisition of agricultural land is prohibited for non-residents, purchase, etc. But under FERA, if you are an Indian citizen, though you are a non-resident under FERA, you are allowed to purchase the agricultural land. So, we had one interesting case where we were able to establish that that person was an Indian citizen but a non-resident. At the time he purchased the property, and at the time of purchase of property, FERA was in existence. So, that purchase was in accordance with the rule, and he became a OCI later. So, when FEMA came in, so that was an eligible transaction.
But in the case of residential property, the repatriation of sale proceeds is restricted to not more than 2 such properties. So, bankers were of the view that if it is a residential property, you cannot repatriate the sale proceeds of more than 2 properties. But the thing is, this is given under the non-debt instrument rules. But if you go to the master direction on the non-debt instrument rules, which is master direction number 12, it says that this is also subject to the remittance of assets regulations, which is master directions 13. So their master direction 13 do not have this condition. It just says you can repatriate the sale proceeds of immovable property. So up to $1 million. So even if it exceeds 2 properties, these 2 properties during his lifetime. So, but here you can't remit, but under that regulation you can remit. So bankers will always say that they just refer this. Under non-debt instrument rules, you cannot repatriate the funds of more than 2 residential properties. But under remittance of funds, which is specific in nature, so Master Direction 13 says remittance of repatriation of proceeds of sale proceeds of immovable properties permitted without any limit on the number of properties. No. And the other regulation which is specific in nature, which allows you the repatriation of more than 2 properties.
So now you can repatriate.
You can repatriate. Yes. Rules, non-debt instrument rules. But if you go master direction on non-debt instrument rules, he says that you refer to master directions on the remittance of assets. There it says remittance of sale proceeds of assets is permitted. Remittance of sale, that master direction 13.
Master direction that precedence over the rules?
Yes. Because that is specific in nature, this is general in nature. Even master directions on this rule also says that you refer master direction on the remittance of assets. That is master direction 13. So that have a precedence. Huh? No, that's what not master directions on these rules says that you refer to master directions on remittance of assets. No. No, that remittance of correct. No, but remittance of asset, there is a regulation which is notified by the RBI.
Both are very same parties.
Yes, but this rules is given by the central government. But still, the RBI has given a clarification that for a remittance of immovable property, sale proceeds of immovable property, refer to master directions 13. I can read the para if you want. See, there is master direction 12. In that, para number 8. See that para number 8. Para number 1. Person acquiring property in accordance with section 6.5 or a successor cannot repatriate outside India the sale proceeds of such immovable property without the prior permission of the Reserve Bank. That is mainly referring to RBI. This is foreign national. However, if a such person is a resident outside India, he can utilize the remittance facilities available under Foreign Exchange Management Remittance of Assets Regulations 2016, amended from time to time. So, master directions on this rule itself allows you the refer to that specific master directions on this specific regulations. This is non-debt instrument rules. So, banker will always rely on these rules. But we were able to convince the banker.
So who to go in this case to a chartered accountant or to the bank?
See, of course, we are executing transaction, we'll go to the banker first. The banker, if we say that one, it cannot be done, we have to give the help of chartered accountant.
Not many will know also.
Yes.
So they just go blindly by what the banker says and then.
See, NRI buying a property, NRI agriculture property in India, registrar will not stop you. No, you are NRI, you can't buy agriculture property. Registrar will execute the transactions. So, borrowing and lending regulations for NRIs and resident. If I want to say in brief, this borrowing and lending is permitted only between the relatives. Between non-relatives, it is not permitted. So, I put up a table presentation, borrowing and lending in INR. Lender is a resident, borrower is NRI OCA, permitted within the allowance limit, 2,50,000, subject to the conditions given there. Lender is a resident, borrower is non-relative, not permitted. That means resident cannot lend money to his NRI friend. It is a violation.
And vice versa?
That also.
Oh, here.
So, lender is NRI, borrower is a relative, and borrower is a resident. Permitted. That also, it says that subject to terms and conditions as specified by the RBI. In ECB regulation, that is regulation number 6B, 6 says that subject to terms and conditions specified by the RBI. But till now, RBI has not come up with any terms and conditions. So whether this is permissible, we don't know. No, but it says subject to such terms and conditions as specified by the RBI. RBI has not come up with any terms and conditions. So whether this transaction, because under still ECB regulation there were conditions. So whether they are referring to that condition only, we are not sure.
Maybe they are getting more money. So
because ECB regulation was amended in 2018. Before that, they had given certain conditions that minimum average maturity period, rate of interest. As under the companies are. So non-NRI will say resident is not permitted. Even similarly, borrowing in foreign exchange. Resident is a lender, borrower is NRI, not permitted. Capital account transactions, which is not specifically permitted, is prohibited. Similarly, person resident outside India who is a relative, borrower is a resident. Permitted maximum $250,000 subject to the terms and conditions again specified by the RBI. Between the non-relatives, it is not permitted. Who is the relatives? Spouse, father, mother, son, son's wife, daughter, daughter's husband, and brother, son, sister. Continuation of loan in the event of change in the residential status. In case the loan was granted by the resident individual to another resident individual and the lender becomes subsequently becomes a non-resident, the repayment of the loan can be made to the NRI account or any other account entered in with the bank. In case loan was granted by the NRI OCA cardholder to a person resident in India in accordance with the provisions containing these regulations and the lender subsequently becomes a resident, the repayment can be made to the bank account, his resident bank account. Just put up the definition of AIO. Yeah, you can continue. Yes. The problem is there are two NRIs. The loan is taken and they were outside India. Now one person comes to India, how he can repay the loan? It is not specifically covered here. You have to go to RBI. Unless he has sufficient funds outside India to repay it.
But in the case of the bank giving the loan to the NRI, how that works? Where that's at?
Bank giving loan to?
NRI.
Huh.
To buy. That is allowed.
Yes, bank will give the loan to NRIs for purchase of property. He can repay it, yes. Yes, that can be used. Acquisition outside India by resident individual, we already covered this. Under LRS, he can buy the property. Penalties under FEMA. If any person contravenes the provisions of FEMA, any rules, directions, regulations, order, notifications, he shall be liable to penalty up to twice the sum involved in the contravention. In case where the amount or values are not quantifiable, penalty up to 2 lakhs. And if it is continuing 1, he shall be liable to penalty which may extend to 5,000 for every day during the period of such contravention continues. So any adjudicating authority may, if he thinks fit, in addition to the penalty, he may also impose such contravention. You can impose for such contraventions directs that currency, security, or other property in respect of which contravention has taken place shall be confiscated to the central government.
The previous one, will the third point apply in almost all cases? It continues.
Yes.
5,000 for every day. If you not change your
It continues. This is about section 37A, which says that if any asset was acquired outside India, which is not in contravention, which is in contravention with the FEMA, and value exceeding 1 crore, the AD, the authorized officer, after recording the reasons in writing, is about to seize the equivalent value of asset in India. This is in addition to penalty and imprisonment up to 5 years. Below 1 crore, only penalty is imposed. I have 2 case studies, then you might know. Mr. John is a British national and a OCI. He is working as a CEO of an event management company that is founded in India in January 2020. He owns a property outside India, which he was purchased when he was a resident outside India. His family also is outside India. Now he is coming to India on employment. As per the definition of FEMA, he is a resident here. He also works for Indian company for about 20 days in a month, and for balance days he goes to UK for providing any professional consultancy services. So he is living in India for the purpose of his business. So there will be dual residency conflict. So what is his residential status? So he comes to India. So till the period he is there in India, he is a resident. But when he is going out of India for the purpose of business, he becomes a non-resident.
20 days, 10 days.
So this is the more practical problem, but RBI has not given any clarifications. So we don't know. So one can take view that both these conditions are satisfied. I mean, he is coming to India for employment, living in India for the purpose of employment. So you may go to that main leave 182 days. So where he was there for more than 182 days. If he is in India, he becomes a resident. If he is outside India, he becomes a non-resident.
One practical decision we have taken in case of one audit client who has a business in India. It's a very auditable case, proprietorship concern. He runs about 20 crores turnover. He has got a business in Dubai. But we asked him to make sure that he stays outside of India at least for 186 to 190 days in a year. And under income tax also he becomes a non-resident, and there also he becomes a non-resident under FEMA because of applying that rule. Because Otherwise, it is a chaos. So some days he will be in India, some days he will be outside. So actually, we are sitting together and discussing these things.
Then case 22, foreign university wants to offer executive management program in India. It has already engaged an exclusive marketing partner in India. However, foreign university does not want the hassle of collecting payments for each participant and wants the Indian marketing partner to collect the participant fees in India on its payoff. So subsequently, the Indian partner could raise the net participant fees after deducting of its commission fees. So can the Indian marketing partner collect the fees in India on behalf of the foreign university? No. It's violation under section 3C. 3 and 3C. Both are covered. So person who is making the payment to the Indian marketing partner, that person also is violating the section 3B, and Indian marketing partner is violating section 3C. And there is also a compounding order, Global Collect India Private Limited, on this similar case. Thank you. Take it up.
Answer most of them.
So I could not go deep into this subject because of the time. We shall have to cover many things.
You are waste to everything knowledge. Yeah, important part.
So your whole practice is only in FEMA?
So we have all FEMA, direct tax, international taxation, GST.
Second session speaker, Sriram V Rao to the dance. Kindly request CA Abhirami to introduce the speaker.
I welcome Sriram sir. Sir is a practicing chartered accountant in Bengaluru and he has done his graduation from Canara College, Bengaluru in 2005. He joined as article assistant under CA S. Srinivas Kamar in 2008 and completed the same in 2010. He was admitted as an associate member of ICAI in Jan 2013 and has completed his CA final by the end of 2012. And as a fellow member of CA in April 2018. Sriram has his credit in the following post-qualification courses conducted by ICAI: Diploma in International Taxation, Diploma in Information Systems Audit, Certificate course on Concurrent Audit of Banks, Certificate courses on Forensic Audit and Fraud Detection, Certificate course on UAE Corporate Tax Law. Sir represents client in appeal matters before departmental authorities, appellate authorities including income tax tribunal. He is also into DT, especially international taxation, and providing advisory and consultancy to various categories of clients. Apart from these, he also handles some of the corporate audits, tax audits and bank audits. He has presented seminars for members of Bengaluru, Udupi and Kannur branch of ICAI, for income tax assessing officers at Bengaluru under training program conducted by National Academy of Direct Taxes, for students of Bengaluru and Udupi, Sikasa, on various topics in direct tax and international taxation.
Thank you, ma'am. I'd like to call CA Satya to present the mentor and adaptation. For the speaker.
afternoon all. Hope the lunch is fine and all are great. We will try to make this session interesting and interesting rather than make the session monotonous. And I would like you all to pitch in wherever you have your own opinion or whatever. Now, I am taking most of the topics from the perspective of a non-resident under income tax law as well as some tax treaty provision. So, majorly I will be covering certain conflicts in residential status. I will not be touching upon the basics of residential status and objectives of tax treaty, important things to remember in application of a tax treaty, features and characteristics of tax treaty, taxation of incomes of NRIs, especially salary income, capital gain, interest and dividend. So these are the topics to be covered. I don't know how far I am able to cover. It's a very long list. So let me see what best I can do with the given time. So the rest definitely Lakshmi ma'am will be able to help us out. So residential status basics everyone knows. Now when it comes to basic, there are two exceptions. In that, one comes with one comes where the person is leaving India for the purpose of employment. So where that employment, whether it includes self-employment, we have decision of Abdul Razak, Kerala High Court, as well as one Suresh Nanda, Delhi Tribunal, which has been affirmed by Delhi High Court. So this says that employment would include self-employment whenever a person leaving India. Then purpose of employment. What do you mean by purpose of employment? Meaning thereby, can a person who is already under employment comes to India, say on 31st of March or something like that. Next year he is again leaving India. Can he be considered under the first exception that he is leaving India for the purpose of employment? So one Bangalore tribunal, one old decision, and also thereafter there are certain decisions which says that purpose of employment is to say for the first time you are going out with an appointment letter or that kind of. If you are already under an employment, coming back to India, then leaving in continuation of the employment, that cannot mean that you are leaving India for the purpose of employment. Hence, it will not be covered by the first exception. So this is one more controversy which has come into picture. There is one Bangalore old decision. Anyway, this slides will be shared, so we will be having all of that. Then, second exception is coming to India. So, when a person is already outside of India, comes for the purpose of visit, then again that 60 days will get replaced by 182 days and also 120 days rule. So, what do you mean by coming to India for the purpose of visit? He has to say continue his employment if he is under employment, or say any other purpose, say education or whatever which activity which is already carrying out outside of India and coming to India for certain fixed period of time. So that means he is coming for the purpose of visit. But if he resigns or terminates his employment and coming back to India, that cannot be considered as a coming to India for the purpose of visit. There are decisions of AAR, earlier advanced ruling, as well as Punjab and Haryana High Court, which says that if after termination of service agreement and later on going outside of India for another in different country, won't be able to get the benefit of the person coming to India for the purpose of visiting. He may get the benefit of leaving India for the purpose of employment whenever he goes, because one employment is terminated, came back to India, now leaving. So that he may get, but when he came back, he will not get the benefit of coming to the purpose of visit, unless he has got another employment, before he comes back. So that's what. Then again, this is one more interesting scenario which has come in before Karnataka High Court. Of course, first tribunal which has held like this and again affirmed by the Karnataka High Court. What has happened is an employee deputed outside of India to US in 2003. In 2004, for about 20 days. He came to visit and then returned back. Then in the month of January 2005, he came back, it was fag end of January. So in February and March he was there in India, 2 months, which was 59 days. Okay, now here was the interesting scenario. During one financial year itself, for one period of 19 days, he came for the purpose of visit. Another period of 59 days, he came for the not for the purpose of visit but for permanent settlement, because he came here to take up an employment in India. So total number of days would have exceeded more than 60. But Karnataka High Court interestingly took a view that he will be a non-resident, because for the first time when he came in between in August, that was not for the purpose, it was for the purpose of visit. So he is falling under the exception to the basic rule. However, when second time he came, he has not fallen under the exception. But during that time, his number of stays in India for that particular purpose was less than 60 days. That is why Karnataka High Court also affirmed this decision that he would be a non-resident for this particular year. So I don't know what is the fate of this case. I don't know whether it has gone to Supreme Court or not, but it's a very interesting case to look into. Then calculation of number of days stay, whether both the entry and exit date has to be considered or not.
Yes.
So my personal view is entry days you have to exclude, then exit days you have to include. That's how normally whenever the number of days has to be calculated, that will be done. This has been affirmed even the monogenity case by Karnataka High Court and also several other IAD. However, there are AAR judgments which are against this. That says that both entry and exit days has to be taken into consideration. But AAR judgments are specific to those cases, so we can we can say that we can rely on the other decisions as well as. Since in the case of Reddy, Karnataka High Court has approved, we can take that stand safely. That's what I mean.
So one interesting fact is that, can you just move a bit on? For the Pradeep Kumar Joshi or Manoj Kumar, in one of these cases, the individual landed in India only around 11:59 midnight, 11:30 midnight,
yes.
And he could not have carried out any meaningful activity in India on that particular day. That is also one of the reasons they said that. Okay,
that is Pradeep Kumar case.
Pradeep Kumar.
Yes,
Okay.
that's Pradeep Kumar case. Because that's why it was also one of the argument taken by the council that he came on that fact time. So that's why the entry date has to be excluded. That was one of the reasons. Anyway, now we have multiple reasons we can. Then again, deep resident, I am not going to touch too deep into that. But however, it is very, very debatable aspect. What is to be included when it comes to 15 lakh egg first or chicken first? That kind of argument also could come in certain fact and circumstances. But for now I am not taking up that because that might itself take 2 hours. Then again, liable to tax. This is like subject to tax, subjected to tax, those kind of things has to be looked into. Liable to tax means a person has a liability to pay tax. It might be exempted in the other country because that other country has a sovereign right whether to tax or not on a particular income. So if that particular person that particular country exempts it, but still, if that overall income is covered by the taxing statute of that particular country, it will be considered as liable to tax. So it has to be subject to tax, but it need not be subjected to tax. That means tax need not be paid to say that the income is liable to tax. So again, this is what I have explained. Then, in favor of the argument what I have already told, we have Azadi Bachao Andolan and couple of other judgments. And against, we have couple of AAR rulings. In this regard, one interesting fact which needs to be considered is the definition of liable to tax came into force only from past 3 years. Prior to that, this definition was not there. At that time, these decisions of Azadi Bachao Andolan and other Mumbai Tribunal as well as Delhi High Court decisions were rendered. So, as on date, what is the sanctity of these decisions in that context? That probably need to be tested in the court. However, this is a pictorial representation one can go through for easy understanding of residential status as per income tax act. And RNOR status, everyone would know, 4 rules that needs to be considered. Then there is the possibility of dual residency. If there is a dual residency, then tiebreaker rule has to be applied as per that treaty. The matrix will be permanent home. If he has got permanent home available to him in both the states, then center of vital interest. If he does not have permanent home in both the states, then directly go to habitual abode. So, if one of the things are satisfied in this matrix, then itself the test ends. So, if he has got permanent home in one country, not both the countries, then there itself test ends. You need not come down the line. So, there itself you can conclude that he will be a resident of that one particular country where he has got a permanent home. If he has got a permanent home in both the countries, then center of vital interest. If he has got center of vital interest in both the countries, or it cannot be determined where the center of vital interest is, then definitely one needs to see habitual abode. Habitually, where he is staying during that particular year or previous years. It depends on very subjective whether this year has to be seen only this year or previous year also has to be seen all that thing. Then permanent home, it is the right of disposal has to be seen. It need not be owned by him or it can be leased out house also, but the right of disposal, that means at any point of time that person can reside in that house. That's what matters to determine whether that person has having a permanent home or not. And center of vital interest, there are multiple things that needs to be looked into. Passive income generation, active income generation, his family relations, and economic relations, as well as his social activities where he is actually doing, all that needs to be seen and then understand and apply where this center of vital interest would be. If it is split, go to habitual abode, habitually where he is normally lived during this year or continuously during say, so many years. Depending on that, one can determine the residential status and break the tie. So, some countries like UAE as well as Kuwait, which were not having residential status, not having tax laws, but recently that also came forth. So they had their rules of residency as per the DTA itself. It said if during one financial year in their context it was calendar year, stay more than 183 days in that country, that person will be a resident. Most of the other countries they refer to their country tax law, individual country tax law. So this is about that. Then objective of a tax treaty, granting of relief for income on which both the countries is levying tax. For that relief has to be given from that, as well as to promote mutual economic relations, trade and investment. For that also relief can be granted. It need not be only for the cases where there is a dual taxation of a same income. Further, for avoidance of double taxation, without creating opportunities for non-taxation or reduced taxation through tax evasion or tax avoidance. So, these wordings are specifically from the MLI, multilateral instrument, which has been picked up and inserted into our Indian Income Tax Act. It says that if somebody is trying to do a treaty shopping and try to evade taxes either by non-taxation of the same income in both the countries or reduced taxation, that cannot be entertained. and for that benefit of DTA or tax treaty cannot be given. Then exchange of information, for that also DTA is entered, as well as recovery of income tax, for that purpose also it is entered. Then section 90 and 98, which is actually providing without under that only, that without creating opportunity for non-taxation or reduced taxation, those wordings are there. So here, as I have already explained, this has been brought in from MLI specifically, as well as it only means non-taxation or reduced taxation of income cannot be allowed. The same is induced by way of evasion of taxes. If there is evasion of taxes or trying to evade taxes, only then DTA relief or tax treaty relief cannot be given. Otherwise, it will be allowed. So, application of tax treaty to apply tax treaty, one person has to be a resident of at least one of the country between which the tax treaty is already entered, and that particular country. If it is already dual residency, then obviously tiebreaker test has to be applied. TRC as well as Form 10F has to be mandatorily received, and Form 10F has to be uploaded online. Then application of DTA provisions are not compulsory, they are optional. Then tax treaty provision can be applied to the extent it is more beneficial to the SSC, meaning thereby if there is an income, it is qua income as well as qua particular income. Say for example, an interest has been received from a deposit, that as per Income Tax Act, tax slab is applicable. But as per tax treaty, if there is a reduced taxes, to the extent it is beneficial to the SSC, we can split those interest income and put into taxes under the slab rate or the tax rate which is applicable as per the tax treaty. That the maximum amount of tax needs to be paid as per the tax treaty. If that is if the SSC is eligible for that, we will look into that little later. Then our provisions will always override tax treaty provisions. If a particular word is used but not defined in tax treaty, then income tax definition needs to be taken into consideration. If the definition of income tax in the Income Tax Act also that it is not defined, then again we can refer to notification, or a general meaning has to be given. Now TRC and Form 10F. This is 90 subsection 4, 90 subsection 5. So in Form 10F, regularly see, the TRC is a tax residency certificate to be obtained from the country where the person is a resident. From the tax authorities of that country, they have to give the TRC. Now the Form 10F, after obtaining TRC, they have to upload the TRC in online portal through Form 10F, in which status of that particular person, nationality, being in that country, as well as his residential address in that country, as well as address of that particular person where he is carrying on the business or he is living, that also has to be provided. If TRC is not available, whether the SSC can take the shelter under any of the rules. My view is, if TRC is not available because of impossibility of performance, which has been held by various tribunal judgments, because of impossibility of performance, then obviously the treaty benefit cannot be denied. But if there is no impossibility of performance, then tax treaty benefit has to be denied. Normally it will be denied. So one can say that now it is possible, earlier also, for UAE, Qatar, those countries where there were no tax law, still their federal tax authorities or finance ministry were issuing tax residency certificate. It was not actually an impossibility of performance. We have cases where we have obtained from those countries where there was no taxes which were applicable. Of course, there are now, and now that tax laws are actually covering the individual taxation on various incomes. However, they have given exemptions to most of the incomes and are taxing only business income as such. Now, if TRC is made available, Can revenue still question the residential status and treaty benefit entitlement? The answer is no. There was a possibility if the finance bill proposed in 2013 under section 19 section Y, subsection 5, if that wordings were continued when the Finance Act was enacted, then there was a possibility. The wordings were the certificate of being a resident in a country outside of India or specified territory outside of India, as may be referred to in subsection 4, shall be necessary but not sufficient condition for claiming any relief under agreement referred to that. So that was the proposed amendment to say it is necessary but not sufficient. But when it became a Finance Act, they just removed all that. They just entered that the SSC referred to in subsection 4 shall also provide such other documents and information as may be prescribed. They prescribed Form 10F. So once, as on date, once DRC is available and Form 10F is uploaded, then treaty benefit cannot be denied. So we have 3 ITT, Delhi ITT judgments in this regard on the same applicable from assessment year 1920, 2021, etc. Very recent books. Then, so features and characteristics of a tax treaty. Tax treaty allocates taxing rates. Benefits of tax treaty can be made available by a person resident of at least one of the country. Protocols, MFN clause and MOUs needs to be looked into and read together. And if there is a MLI provisions which is impacting, that also has to be read together when tax treaty is applied. Further, tax treaty tend to be less precise and require a broad purposive interpretation. Meaning thereby you can't go too technical into certain words used in that. You have to understand the tax treaty from a layman's perspective. And generally, the benefits of Article 6 to 22, that is taxation of income, they are applicable. They would be more beneficial to a non-resident from that perspective where the income is sourced, not to a person who is a resident of that country. However, there are certain exceptions. We will look into that whenever we go further. Then, Article 23, that is elimination of double taxation, that is available to a resident, that is claim of foreign tax credit. Then, of course, these wordings we will look into whenever we are looking into certain aspects of tax treaty. Now, this is the structure of tax treaty. We will directly look into 4 articles or 4 nature of income which we have covered. Now, certain important factors which needs to be looked into from the perspective of application of tax treaty for a non-resident individual. That is 44AD, 44ADA, those provisions are not applicable to a non-resident. No option for limiting the tax by indexing the immovable property on capital gains to non-resident. That is, after if the property is sold on or after 23rd of July 2024. Senior citizen, super senior citizen, those categories are not there. Advance tax needs to be paid by that non-resident. Then no Chapter 68 deductions on certain incomes which are taxable at special rate of taxes, including dividends which are taxable under 115A. No rebate under section 187A for NRIs. So these are specific things one need to look into from NRI taxation perspective. Now let us look into taxation of salary income. So section 15, any salary due, any salary paid, any arrears of salary paid or allowed, those are covered as taxable. That is from the Indian tax perspective. And again, section 912, which deems to accrue or arise in India, defines salary income if it is earned in India. So now, what do you mean by earned in India? That is again given in the explanation. Salary payable for services rendered in India and the rest period or leave period which is preceded or succeeded by services rendered in India and forms part of the service contract of the employment shall be regarded as income earned in India. So, if a person is working from home to a foreign employer, is it service rendered in India? The answer is yes. That meaning thereby, if a person, as per Income Tax Act, without referring to tax duty, under Income Tax Act, if a non-resident comes to India for the purpose of business, then he continues to work from home. At that time, the salary which is earned by him and deposited into foreign bank account would be deemed to accrue or arise in India as per 912 and liable for taxes in India as per provisions of Income Tax Act. So, even the non-resident can be liable for taxes on work from home situation if he is located in India while rendering his services. I mean, am I right now? So, again, we can look into UN model or OECD model, almost similar. No much this one when it comes to dependent personal services, Article 15. Now, subject to the provisions of Article 16, 18 and 19, salary wages received remuneration derived by a resident of a contracting state in respect of employment shall be taxable only in that state unless the employment is exercised in the other contracting state. Meaning thereby, a resident of a contracting state employed outside of India working there, he will be liable for tax only there unless the employment is exercised in the other contracting state where he is a non-resident. So, if the employment is so exercised, that means if he exercises employment in the other contracting state, such remuneration as is derived therefrom may be taxed in the other state. That means it may be taxed. May be taxed means up to the other country to tax it or not. Where if it is taxable as per their domestic tax rule, it will attract tax. So, if a person non-resident to India rendering services in India will be liable to tax because of 912. However, para 2, which gives an exception, which is notwithstanding any of the provisions of para 1, in respect of employment exercised in the other contracting state, that is in India, shall be taxable only if all the three conditions are satisfied. So, it will be taxable in India if his stay in India exceeds 183 days and the remuneration is paid by or on behalf of an employer who is not a resident of the other state, that is India. He is not a resident of this country, and the remuneration is not borne by the permanent establishment or fixed base which the employer has in the other state. So we will look into with some example for this. So if these three sections are cumulatively satisfied, then the work from home situation from India will be taxable only in the first country where he is a resident. It will not be taxable in India. So, non-resident working from home in India can bring their taxation of salary income under para 2, which we normally call it as short stay exemption, and make that it will not be brought to tax in India, so that avoid the double taxation. Then para 3, notwithstanding the preceding provisions of this article, remuneration derived by a resident of a contracting state, this is basically for shipping or airways where the vessels are traveling in international traffic, for those people who are receiving salary from there shall be taxable only in the first mentioned state, that means where the person is a resident. So we will take Kuwait DTA or easy understanding. I have just randomly taken this, there is no reason as to why this treaty has been taken. Salary, wages and other similar remuneration derived by a resident of Kuwait in respect of an employment shall be taxable only in Kuwait unless the employment is exercised in India. If the employment is so exercised, such remuneration as is derived therefrom may be taxed in India. Then paragraph 2, resident of Kuwait exercised employment in India, salary taxable in Kuwait, only in Kuwait, if he is present in India for for periods not exceeding 183 days, that is stay during 12 months period, and remuneration is paid by or on behalf of an employer who is not resident of India. So that means he would be a resident of Kuwait, and the remuneration is not borne by a permanent establishment or fixed wage which the employer has in India. So in India they should not have P. Normally this would be the case unless it's a MNC where they are deputing employees. So with this background, I have a case study. Mr. X, a person non-resident in India for past 15 years and a resident employed in Kuwait comes to India for a vacation of 2 weeks on 1st May 2023, and thereafter due to unavoidable reasons gets stuck in India. His employer allows him to work from home till the end of October 2023 and he returns to Kuwait on 31st October 2023 and does not return to India till 31st of March 2024. He had worked from home from first third week of May till the end of October and earns salary which gets received by him to his Kuwait bank account. Will his salary income be liable for taxes in India 23-24?
No.
Answer is correct. No. But my thing is 1st May 2023 and up to 31st of October 2023. His stay in India is exactly 183 days. Pardon? Yeah. So exactly 183 days. Okay? Interestingly, if you go back and check the Kuwait DDA, it says 183 days stay in that country also, and he is satisfying that. He is satisfying that. But 183 days stay in India, he becomes a resident in India. Of course, he is a RNO, that's a secondary, but he becomes a resident in India for this financial year. But as you rightly said, he will not be liable to tax, provided he is able to obtain a TRC from Kuwait, which is possible because they stay in Kuwait also 183 days, and during this 23-24 financial year, it's a leap year, 366 days. If it was not a leap year, then he would have been 182 days in Kuwait. He may not have been able to obtain TRC. At that time, scenario would have been totally different. So again, if he is not able to obtain a TRC, will he be able to satisfy the tax authorities? That is impossibility of performance. That's also a question. And will he be a tax resident of Kuwait? That is also a question, as per their tax law present for this financial year. So, with that, it's a very debatable and this one, but for this year, it is very, very possible for that person to claim the short stay exemption. If Mr. X continues to work in India for one more week, that is till 7th November 2023, and then returns to Kuwait, will his salary income for the financial year 23-24 be taxable in India? Here the doubt which came to me was 183 days, whether he should be working as an employee in India. But in my view, and after looking into the provisions, it is not referring to working days of 183 days, it is referring to number of days stay. That is where my interpretation goes here is, yes, he will be liable to tax because his stay in India has exceeded 183 days, and that's why short stay exemption would not be available to him. And only the income which is earned for that particular period will attract tax in India, because only that income is due to accrue in India. Again, residential status, this is an exception rule what I said, that to the general rule, because here even though he becomes a resident because of 183 days stay, he will be able to claim the short stay exemption, that is the benefit of tax relief. So with this I have ended up on dependent personal services and conflict, whatever I was able to understand, because it's a very small. Now let us look into capital gain, sale of unlisted share for debentures invested in foreign currency. There is a specific provision under section 48, first provision, which says that if there is a investment by a non-resident in foreign currency for purchase of shares or debentures invested in India. So now shares or debentures other than unlisted, because if you go to taxation of unlisted shares, it is specific provision which is not even giving indexation benefit under 112 1C. Taxation is 10% earlier, now 12.5% without this one. At that time, in that provision again they have excluded this proviso in specific, saying that this proviso is not applicable if you are once you are paying tax as per 112A 1C. That's why this proviso is not applicable to unlisted shares. But if it is a listed shares or debentures, this proviso will be applicable. This proviso simply says, if the person has invested in a foreign currency, then now earns a capital gain, convert everything back into the foreign currency in which he has invested, calculate the capital gain, and that you convert back into Indian currency. So this is one specific rule which is applicable to a non-resident when he has invested in foreign currency in shares or debentures other than unlisted shares. So again, there are such, I am not going deep into 911 where that indirect transfer, etc. We will look into that when the actual DTA tax treaty provisions which we are looking at. Then again, taxation of LTCP in the hands of non-residents, section 112 1C and 112A. They are the applicable section. For unlisted shares, it is 10% earlier, now it is 12.5%. Both without indexation, and both the proviso, first and second proviso under 48 is not applicable. First proviso being invested in a foreign currency not applicable. Second proviso under section 48 is indexation. Then if it is in shares, equity shares or equity oriented mutual fund or units of business trust, earlier it was 10% and 12.5% now, both without indexation on under section 112A, this and any other assets, other long-term assets. Again, at 20% tax rate with indexation if transferred prior to on or prior to 22nd July 2024. Or 12.5% if transferred on or after 23rd July 2024, that is without indexation. So this is the tax Indian income tax provisions as far as taxation of capital gain is concerned. So applicability of which rate to apply when you are converting back and forth. 115A rule has specifically provided full value of consideration that has to be converted using average TT buying rate and TT selling rate on the date of transfer. Then cost of acquisition has to be converted using average TT buying rate and average TT selling rate as on the date of acquisition. Expenditure also on the date of expenditure, on the date of transfer, and convert everything back to foreign currency, calculate the capital gain without indexation, then convert back into Indian currency using TT buying rate. as on the rate of transfer. Only TD buying rate, no average rate. When you are converting back to foreign currency, everything is average of TD buying and TD selling rate. When you are converting back to Indian currency, the entire capital gain, then TD buying rate. And this TD buying rate or TD selling rate is SBI TD buying rate and SBI TD selling rate, not RBI rate. Case study, Mr. X purchases 1000 shares of a company at ₹64 per share by investing $1,000 on 7th February 2018, when SBI TD selling rate was 64.2. The shares were sold by him for ₹150 per share as on 10th February 2022. What is the taxable capital gain? Considering the average TD buying and selling rate is 75 rupees on the rate of transfer, and SBI TD buying rate is 74.75. So I have done this calculation. It will, see, if you are directly calculating, then 1,50,000 less 64,000. So 86,000 would have been your capital gain. If you are converting back and forth, then 74,867 would have been your capital gain, taxable income. So practical aspect, how you present it, there is a specific column under in your idea. If you are using Winman or your computation, here units of unlisted shares of non-resident, first provision to section 48, that needs to be selected so that you can directly enter the capital gain. So this is the practically how you fill it. Then capital gain, we look into provisions of ETA, now tax treaty. OECD model provide that gains derived by a resident of a contracting state. See, normally para 1 is movable property. So it may be taxed in the other state. That means where the source, there also it will be taxed. Where the resident, the person is, there also it will be taxed. Now, para 2 is most of the times applicable when there is a movable property forming part of a business or a permanent establishment. It again may be taxed in the other state. That means it will be taxed in the resident state as well as it may be taxed in the source state. Then gains that an enterprise of a contracting state that operates ship or aircraft which is running in international traffic shall be taxable only in that state where that enterprise is registered. Otherwise it is going to create chaos. Where you will be taxed. So like that. Then para 4 generally refers to taxation from alienation of share or interest in any business. So those are taxable in both this state or that state, and again there are certain additional conditions which may be provided there. Then main here is there is a big possibility to provide lot of tax saving avenues as well as tax planning from the perspective of other assets, wherein those other assets would attract tax only in the country where the alienator is a resident. That means in the source state it may not attract tax also. So any asset other than this, most of the time this is possible. There are some countries which won't even have these clauses, but most of the time it is possible. We will look into that. Again, I am taking Kuwait DTA. No, para 1, sale of movable property. Seller is a resident of Kuwait. Buyer, wherever he is located. Property is in India. It may be taxed in India. May be taxed in India means it will be taxed in India, because as per Indian Income Tax Act it will be taxable in India. Para 2, there is transfer from A to B. He is a resident of Kuwait. Movable property forming part of business or permanent establishment which is based out in India. It will be taxable in India. It will be taxable in Kuwait also. However, subject to Kuwaitian tax law. Then alienation of assets, that is ships or aircraft operated in international traffic, where resident of Kuwait having enterprise in Kuwait, then it will be taxable only in Kuwait. It will not be taxable in India. Then transfer of shares by a resident of Kuwait in a company X, which is deriving most of their asset value from an immovable property situated in India. It may be taxable in India, that means it will be taxable in India. That is where, explanation 5 to 911, that is indirect transfer of assets, will come into picture as far as Indian income tax is concerned, as well as paragraph 4 is also covering. Paragraph 4 of tax treaty says that it may be taxed in India, that means it will be taxable in India. Then, Mr. A, transfer of shares any other shares which may or may not derive most of its value from assets located in India or otherwise, whatever it may be. If shares in the companies other than the paragraph 4 is a resident of India, that is the company is a resident of India, then transfer of those shares to somebody, it will be taxable in India as per tax treaty also. But when it comes to paragraph 6, which is transfer of any other asset other than whatever we have discussed earlier. So there are n number of assets, and most common assets which non-resident individuals are using are mutual funds. They are having those incomes. We can plan them in such a manner that they can save on lot of tax if they transfer those assets before they become a resident in India. Meaning thereby, at that time, those capital gain incomes will never attract tax in India. It will be taxable only in Kuwait at the time when they are resident in Kuwait. So, this is one advantageous thing in capital gains. Most of the treaties, France, Germany, Austria, Belgium, Singapore, Oman, UAE, Qatar, Saudi Arabia, Malaysia, Indonesia, they are all having this. But in Singapore, there is also a concept of limitation of benefit that needs to be taken into consideration, because that's one thing which I found difference in these treaties. In limitation of benefits in Singapore treaty, it says that it will be the benefit of tax treaty will be available only if the funds are remitted back to Singapore. After sale of those mutual funds, if the funds are remitted back to Singapore, only then benefit of this would be available to that particular person. So it has to go back and come back. No problem. Of course, again, it is going to be a very challenging now after introduction of MLI into the treaties, wherever they are impacting, to say whether this kind of tax planning becomes a tax evasion or not. My view is, I am not doing a treaty shopping. I have been resident of that country for a long period. I was working there, whatever. From there I have invested in India, whichever country. I am regularly also, I am actually, selling of mutual funds and, again reinvesting and all those things. At that time also I have been claiming. So it is not a new thing to me. So, at the time of me trying to return back to India on permanent basis, once I will exit entire portfolio, arrive at whatever capital gain, claim exemption, then after 2 days I will reinvest. So I have been doing this all the way along, except for the fact that I have not exited the entire portfolio. So, am I trying to evade taxes or evade taxes here? The answer is this provision was in existence from earlier also. So the argument should be that I have been doing this for many years. So that is why I am not trying to evade. It has been my regular practice. That is why I am not trying to evade taxes. It is a proper tax planning mechanism. That is why I should be allowed this deduction. Otherwise, MLI preamble 6, that's which has been inserted under section 90. That is to say that if a person is trying to avoid taxes for not getting taxed that particular income in both the countries, they may attract tax. So in most of the other countries it will attract tax. Except for some countries like Oman, UAE, Qatar, Saudi Arabia, etc. It may not attract tax, even in Singapore for that matter. Because they are not taxing I think capital gains which are earned outside of India. So that's where some issues may come up, but it's very challenging. One can always continue to make this tax planning to their client. So if you come to other famous countries, US, Australia, Canada, UK, they are not having these clauses at all. They are directly saying whatever asset, it will be taxed in both the countries. I am also taxing, you are also taxing, so we don't have anything. But say Australian resident for all these years, 1 year he stayed in Singapore and became a resident. That time he is trying to take that benefit. That may seems to be more of treaty shopping play. So that may not be allowed to claim the benefit of double non-taxation. But otherwise, that this provisions can be. And again, under ITR also there are specific provision in Schedule CG capital gain. There is specific provisions where one need to enter into all these kind of income. And under Winman also you have specific provisions after entering into whatever the capital gain earned. You just enter into these details and rate of tax as 0. Obviously, entire income will be claimed as exempted. Whether mutual fund can be considered as shares? It's a very obvious answer, no. But again, for whatever reasons, department has gone up to tribunal. Couple of judgments we have for Chin 98 as well as Mumbai LGD in these 2 cases. Now, income from other sources, we have 2 incomes, interest income as well as dividend income, which I have to cover now. Now, interest income, obviously, under Income Tax Act section 56, it will be brought to tax under income from other sources. I did not explain much, but under OECD model convention, interest arising in a contracting state and paid to a resident of other contracting state may be taxed in that other state. However, the interest arising in a contracting state may also be taxed in the state according to the law of that state. But if the beneficial owner of the interest is a resident of the other contracting state, the tax so charged shall not exceed 10% of the gross amount. So this is what OECD guideline. Obviously, there will be changes in this wordings when it comes to specific tax treaties. The term interest as used in this article means income from debt claims of every kind. So whatever kind of interest, the interest should emanate from claim of debt claims. So that means there should be a debt which is already given from that interest claim. However, if that interest is earned during the course of carrying out the business operations, then it will be covered under Article 7 because it will be taxed as a business income and it will not be covered by interest article. Again, interest shall be deemed to arise in a contracting state and the payer is a resident of that state. Where however, the person paying the interest, whether he is a resident of a contracting state or not. But if such interest is borne by the permanent establishment, then again permanent establishment will come into picture if there is a business transaction which is being carried out. That is where this will be taxable under business incomes, Article 7. That's what this particular para says, para 5. Then, where by reasons of a specific special relationship between the payer and the beneficial owner or both and some other person, the amount of interest having regard to the debt claim for which it is paid exceeds the amount which otherwise would have been paid, agreed upon by the payer and the beneficial owner in the absence of such relationship. That is, means again arm's length principle that needs to be taken into consideration. The provisions of this article shall apply only to the last mentioned amount. That means it will apply only to the arm's length amount. If it is exceeded, then for the extended amount, these provisions of reduced rate of taxes will not apply, may get taxed in both the countries. Again, the beneficial owner, the word beneficial owner is generally used to replace the word paid to a resident, but it wanted to make it more specific. That's why the word beneficial owner is used. However, agent, nominee, conduit company acting as a fiduciary or an administrator, even though they receive interest directly, are not the beneficial owner, because the recipient right to use the and enjoy the interest is constrained to the contractual obligation which they have with the actual owner. So the legal owner, beneficial owner, or for that purpose, there will be certain bifurcation. The interest earned will be taxable in the hands of the beneficial owner and not the actual legal owner as such. Where the recipient of interest does not have the right to use and enjoy the interest, if the recipient of interest does have the right to use and enjoy the interest, and it is not constrained, then that person who is receiving the interest itself will be considered as a beneficiary. So, that is only reason why the word beneficial owner is being used. Normally, this need not be looked into of very technical meaning, needs to be looked into more of generic meaning, what beneficial owner would actually mean. Now, if you come to again India Kuwait DTA, para 1, interest arising in India paid to a resident of Kuwait who is a beneficial owner may be taxed in Kuwait, but it will be taxed in India. Now, interest arising in India paid to a resident of Kuwait who is a beneficial owner may also be taxed in India, but maximum rate of tax is 10%. Similar rate is applicable for France, Germany, Oman, Qatar and Saudi Arabia also. Whereas UAE has got a little reduced rate for one particular type of transaction, that is 5% of the gross amount of interest if such interest is paid on a loan granted by a bank carrying on the business of banking, or 12.5% of the gross amount in all the other cases. So, for other cases, general cases, it is 12.5% reduced rate. USA has got 10% for gross amount of interest if such interest is paid on a loan granted by a bank carrying on a bona fide banking business. Otherwise, it is 15%. Whereas Australia, Canada, UK has got maximum rate of 15%. So again, there are specific columns wherein this rate can be made applicable, but interest income is taxable at slab rate. So, if the tax slab rate is more beneficial, to the extent it can be applied under tax rate at a lesser rate than the rate which is specified under tax treaty, those incomes can be separated and claimed as taxable as per those lesser tax slab rates. The incomes which are taxable at higher rates, interest income, can be bifurcated and claimed as taxable as per tax treaty rate, which is a maximum rate, which can be made applied. There are specific ITR columns wherein you have to specifically mention and claim these benefits. Of course, obtaining TRC and uploading Form 10 is mandatory before filing return. exemption under the Income Tax Act for interest income, that is section 10, subsection 4, and clause 2 there. It is specifically in the case of an individual, any income by way of interest on money standing to his credit of NRE account, they are exempt provided the NRE accounts are maintained in accordance with the provisions of FEMA. So, it is irrespective of the residential status of that individual under Income Tax Act, if that person is a non-resident as per FEMA and eligible to maintain the NRE account for any kind of period during the year, the interest earned for that period will be eligible for claiming exemption under 10(4)(2). If the residency gets split for a particular person, say a person leaving India for the purpose of employment, his stay in India exceeds 182 days, he becomes a resident as per Income Tax Act. But as per FEMA, on the day he leaves India, he becomes a resident. He becomes a non-resident under FEMA. He is eligible to open NRI account, get interest from that day till the end of the year. Even though he is a resident as per Income Tax Act, the interest earned from such NRI accounts is eligible for claiming exemption under 10(4). And vice versa is possible when he returns back to India. Exemption is available only till the day he permanently returns to India. After that, it will become taxable. So, then taxation of income of FCNR or even RFCF, they are covered under 10(15)(4) FA. This particular clause, which specifically says a person who is a non-resident or a RNO, that is residential status under Income Tax Act, they are not concerned about the residential status as per FEMA. Because as you all know, Dhanush already explained, FCNR accounts or RFC accounts can be continued by a resident also, if such FCNR accounts are opened during the period when he was a non-resident. So, this FCNR interest can be claimed exempt when the person is a non-resident or a RNO. That is where the difference between taxation of NR interest or FCNR interest. That's the only difference. Normally, one can also plan that when a person is trying to return back to India, he can put in FCNR account for 5 years period or something like that, and keep the money on repatriable basis. Say after 5 years, if he wants, he can use that money to pay outside of India. After converting that FCNR to RFC account, after the date of maturity of that FCNR, because FCNR cannot be renewed once that person becomes a resident as per FEMA. Then Chennai Tribunal, Mumbai ITT, Agra Tribunal has already given in favor of the SSC to say that it is immaterial to see the residential status under Income Tax Act from the perspective of taxation of interest on NRE under and claiming exemption under 10(4)(2). However, Delhi Tribunal, in the case of Ravindra Bedi, has deviated from this, and they have actually remanded the matter back to the file of the CITFX to see whether that person is a resident as per Income Tax Act to tax interest earned from NRA account, which I personally don't agree with humble my submission on that. However, this view of Chennai Tribunal, Mumbai Tribunal as well as Agra Tribunals, in my view, it holds more weightage as of today. Again, it comes to dividend income. Now there are 6 clauses A, B, C, D, E, F as per Income Tax Act, taxable in the hands of non-resident under section 115A, 1A, 2, and the rate of tax is 20%. So there is a specific provision to tax these dividend incomes at a special rate. I don't know how it was in Chennai, but when that DDT has been revoked or repealed, most of the people in Bangalore has done this mistake of bringing into tax these dividend incomes under a slab rate in the hands of non-residents. So they ended up getting a lot of notices. They had to correct and they had to convince the non-resident to pay the tax at highest slab rate of 20%. I don't know how it was here. That's why I specifically included this, otherwise I didn't. Then dividend, OECD model, dividend paid by a company which is resident of a contracting state to resident of other contracting state will be taxed in the other state. Of course, again, beneficial ownership concept will also has to be looked into, and if the dividend income will be taxable only in the hands of the beneficial owner and need not be taxed in the hands of the legal owner if the beneficial owner and legal owner are different persons. And the rate of dividend, again, they have given multiple criteria for certain tax treaties. In certain tax treaties, it is very straightforward. Whereas OECD model, which gives 5% rate if the person holds at least 25% or more than the stake in that particular company for a continuous period of 365 days, or in all the other cases 15%. These conditions may be different from tax treaty to tax treaty. The term dividend, as is used in the article, means income from shares and not being a debt claims, because debt claim is covered as interest. Again, if the beneficial owner of dividend, being the resident of contracting state, carries on a business in the other contracting state, the dividend income earned by that business entity, if it is taxable as a business income, that will be taxed as the business income to Article 7 and not under Article 10. And this is again, if there is a sanction mechanism that needs to be looked into. If the dividend received is more than it should have been otherwise, then obviously the excess dividend cannot be would not be eligible to claim the benefit of this tax treaty. So, India Kuwait TTA, dividend paid by company resident in India to dividend to a beneficial owner of a dividend being resident of Kuwait may be taxed in Kuwait. That means, Article 2, it will be taxed in India because dividend paid by a company which is a resident in India, company is a resident in India, will be taxable in India. But again, maximum rate of tax is 10%. UAE, France, Germany, Austria, all these tax treaties cover this 10% tax rate. Whereas Oman has got two different rates, 10% as well as 12.5%. 10% if the company's stake is at least 10% or more by that individual. Saudi Arabia has got 5% rate of lower rate of tax on the dividends. Qatar 5% as well as 10%. USA is having 15% if the stock holding is 10% or more, or 25% if in any other case. Australia has a maximum tax rate of 15%. Canada has got two rates again, 15 and 25%. UK also has got two rates, 15 and 10%. This is specific column under which one has to put the dividend income which is taxable. So here also it has to be specifically mentioned whether the tax treaty, whether the TRC is obtained, and under which article, what is the rate of tax under normal income tax act, etc., etc. So this is a pictorial representation of practically how one needs to cover. So with this, I have come to the end of my presentation. I hope I am able to justify the topics given. In fact, yesterday morning after I landed here, I came to know the specific things which I have to cover. I had prepared something different. Then myself and Dhanush sat together and bifurcated and it was a different thing altogether. And even the organizers, they told that this particular session has been arranged along with the basic to international taxation course which is being carried out. So this I came to know only yesterday. So that's why we tend to change the things. I didn't have ma'am's number, otherwise I would have contacted her and told something so that we could have done it in a better manner. I spoke to her just now and she was she was able to say that you do whatever, I will see what the rest left and I will take care. So I thank ma'am for that. She has given the liberty to take whatever topics which I have started. And last but not the least, I would like to thank the organizers as well as all these delegates who have come over the last day of tax audit, extended date. But still you people are here to listen to us. Thank you very much for patience here.
See, just to keep it really light. That's okay. So this is the very room where I started, I should say, my post-qualification. My first GMCS session, we had it in the same room. So it was quite nostalgic and then be a CP speaker in the same room. Myself, Lakshmi, I'm an executive director with Diamond. I got qualified in November 2006, and from then I've been with the lawyer for the last 17-18 years. And representing the, I specialize in tax, basically for the same topic on the NRIs and PIOs for most part. Glad that we are able to have a very good patient listening audience, particularly on a Monday, particularly on a Monday morning. We're not quite getting disturbed by the routine stuff that we go through. And I also have my colleague Lakshmi who supported me in, we also had a similar exchange of conversation to frame how we should put this slide across to the audience. So you please, let's have it conversational wherever you think that you need to stop or pause or make it a bit more fast depending on the pace. You please let me know quite. So this is how I have framed the entire. This is how I have framed the entire agenda. But want to quickly check with you, how many of you have gone through the residential status section already as part of the basics of international taxation? Yes, it's covered already.
Morning it was on FEMA.
It is on FEMA. Okay. So would you like me to go through the residential status as per the domestic provisions? Would be a quick refresh or no? Yeah, okay. So I'll go with the flow. The first one is the definition of NRI and OCI. It won't take more than 1 minute. And then we come to the scope of taxable income and giving an overview of how these incomes are to be taxed. And definitely on NRI account, it's an overlap, so we will not be looking at that. And for salary, yes, it's an overlap, so we will be looking at it. Probably I will go to the case study directly, so that we can refresh it. And then it's going to be a deep dive into independent personal services, director fees, pension and social security, and other income. While I will be taking up the independent directors and director fees, my colleague Lakshmi will be taking up the pension and other income part. One part which I have left here is about the gift, which is a new insertion into the section, right? That is also covered, but not put as part of the agenda. So, as we all know, NRI is a person who is obviously a citizen of India but settled abroad, and OCI is always a foreign passport holder but comes on a visit to India. So that's something which I have inserted to give a context. On the residential status part, from the time I got qualified till COVID happened,
the definition has been the same. It happened, the change in the residential status happened almost at the same point of time, just for getting that into your memory. Right? Until that point of the time, residential status, the definition say nothing has changed, and we never found that there can be an opportunity for an anti-abuse provision. I don't even think that it is possible, but it looks like quite a few people have explored that an abusive provision is possible. So we have got a lot of insertion into the section 6 to make sure that there is no anti-abuse. The first one, which is a basic condition which we all know, is if you stay in India for 182 days or more, you definitely qualify as a resident of India. The second limb of the condition is that if you stay for 60 days during the particular tax year and 365 days or more in the previous 4 years, you are a resident. That is how it has been all the time. Now there is a change in the condition. This 60 was always replaced by 182 days for a person who is taking up employment and also for a person who is coming on visits to India. So there is no problem as regards people going for employment because they never return. They know how to make good money outside India and they part themselves outside India for a nearly good lot of period. But with respect to people come to India on a visit, we need to see why this provision was there in the first place. Because a lot of Indians who live abroad, or it could be an OCI or it could be an NRI, they come to India for meeting their family members and also for supporting their family in case there is an emergency. They stay in India for quite a long time. And they may also have immovable properties by way of inheritance, or they may have left some properties in India, and to manage that they may have to come to India. So that is exactly the reason why this exception of 180 days was provided in the Income Tax Act. Now the government had come to know about a few possibilities where individuals organize their stay in such a way that they stay less than 182 days in India, and then also 182 days in the other country, become non-resident of 2 locations and not paying tax at all in India. Right? So what the government felt is that we need to make some change to the provision, and they said that if you are receiving substantial income from Indian sources, which is defined as 15 lakhs, if you are deriving 15 lakhs or more from Indian sources, then it's not 180 days condition, then we will only see up to 120, between 120 days or more or up to 180 days, you will definitely be qualified as a resident but not ordinary resident. Earlier, it is only 182 days. Now, the moment a person is having 15 lakhs or more of income from Indian sources, we never go and see 182 days condition. The person straight becomes a not ordinary resident. Okay, so just to so this is how the not ordinary section, resident section now looks like. This is almost the same for these two are the additional conditions. Number 1, if you are a citizen of India or as a person of Indian origin having an income exceeding 15 lakhs, then it is up to 120 days or more, but less than 180 days. So you will become a non-ordinary resident if you meet the minimum income condition. And I'll tell you why this is inserted after coming to this. So the last part is, there are people who smartly say that I qualify as a non-resident of India. I also qualify as a non-resident of another country. So thereby, I don't pay taxes in both countries. To plug this loophole, we have one more addition here saying that it is applicable only to a citizen of India. It is not applicable here, it is applicable to both citizen as well as a person who is coming to India on a visit. The last one is applicable, the deemed resident concept is applicable only for a citizen of India who is who can be deemed as a resident of India. Right? So any person, for example, whether it is an OCI or a PIO or a NRI, if he visits India and he stays for 120 days or more and has a substantial income, definitely passes this not ordinary resident test and they come here. The last one is, if the person is a citizen of India and then he is earning, he is not a resident of any other country. He is not a resident of India and is not also a resident of another country, and is also not paying any tax in the other country, then he becomes a deemed resident of India. So what they are trying to do is, the only difference between not ordinarily resident and non-resident, as you may be aware, is the only difference it makes on the business controlled in India, right? So the reason for this is that you should not be a HNI running a business in India, making money out of it, receiving all the proceeds outside India, and then say that I'm a non-resident, I'm not getting taxed in India because this money is accruing outside India and also received outside India. So if you have a business connection in India, I would like to make you as a not ordinarily resident and make you pay taxes for that income. So that is the intention behind both the changes that are there now in the residential status section. So to just explain this to you in a very simple way, if you are a citizen of India, this is only for a deemed resident. If you are a citizen of India, yes, and liable to tax in other country because of your presence or by way of your residence, then you will not even get into the sections. You will go by the regular section. For example, if you are a resident of a particular country because you stay, then that country has the right to, just because you become a non-resident, we are not going to tax you. Only because by applying the regular provisions, then we are going to tax you. If some other country is having an upper hand on account of residential status, only that country receives the right to tax. Then, if you are not having an income from more than 15 lakhs, then you become a deemed resident, deemed to be a not ordinarily resident of India. The deeming itself, it means that which otherwise you would not have become a resident. For example, let's say that the person itself staying less than 180 days, right? Here, you will have to satisfy all the conditions to become a not ordinarily resident. Let's assume that the person is staying for less than 60 days in India, for example. Then, definitely we will actually classify him as a non-resident. But he is having a heavy business in India and he is not becoming resident of any country, but doing substantial operations. Then, even though you have not even satisfied the basic conditions, you are deemed to be a not ordinarily resident. So that is the effect of this section. So you don't even come to it. You just go up straight away. If you are a citizen of India, having a substantial income, then not paying taxes in any country, then you better pay tax in India. So here I think it would be an overlap, but yeah. D is a citizen of USA and OCI. He stays in India for 130 days and less than 300 days. Derives income in India for up to 8 lakhs. What would be his residential status? You can take a minute to digest this. Anything is okay. Non-resident. This one. He is again a OCI, she is again a OCI and a tax resident of Singapore. Stays in India for 160 days, so more than 120 days, she is satisfying the condition. Derives more than 20 lakhs and the tax liability in Singapore is big.
Resident but not ordinary.
So there are certain things that you will have to see. For example, yeah, I think this is sufficient for this section. So if you see section 9, these are the popular thing that you would have seen. This is already covered by way of capital assets and any salaries that is earned or derived in India, and then dividend, then interest, royalty, fee for technical services, and then the gift paragraph which we have. So these are incomes which are deemed to be received, deemed to accrue or arise in India. The entire reason why we have this provision is it is otherwise not accrues in India. That's why we are trying to bring all the deeming fiction. So coming to the case study on the salary part. Okay. H is a citizen of India. He moves to Japan for 2 years for a job. He receives, these are live case studies because he would definitely, as a practical chartered accountant must be in practice, you will see this in practical scenario. He receives a portion of salary in Japan and a small portion of a salary in India just to continue the India PF and the India gratuity. And he's a non-resident in India because he never returned to India. His physical presence is less than 60 days. He's a tax resident of Japan. So this person has access to tax treaty because he's a resident of Japan. Ideally, his income, he's an India tax non-resident. So there are no conflicts. It's a clear case of a person becoming a resident in one country, non-resident in India. But he has one income in India, which is a salary income from his employer, Indian employer. So, will he be taxable on the salary that he receives in India? Yes. The straight answer is yes, based on the domestic provisions, because this income is received in India. But the answer is no. Okay? Because there is an opportunity to explore. Right? If you see the section, if you see the article 15 here, the salary is taxable only in the country where the employee is exercising the employment. Right? The source country only has the right to tax. In India is a non-resident. Right? So here it gives right. This gives right to the resident country, and the exception is if he works in another country. The country where he works, it shall be taxable only in that country. Right? So in Japan, he may be paying tax on the full income. That's how it works. Any country where the employee works has the upper right to tax. Just because that person is using that particular country's soil and economic resources to earn that income, so that country has the right to tax. So as far as the salary income is concerned, only Japan has the right to tax the income that he receives in Japan as well as the income he receives in India. So there will be a double taxation to the extent of the salary that is getting paid in India. So what you have to do is, if you encounter the situation, based on the India-Japan double taxation avoidance agreement, you need to claim exemption for the salary that is getting paid in India. In most cases, if the company is going ahead and then deducting the TDS, you have an opportunity to reverse it and claim it as a refund by uploading the TRC and other stuff saying that this person qualifies as a resident and therefore this income is not taxable in India. Anything else? There seems to be.
Like my friend had a similar she asked me because he is an NRI, he works for some Wipro. Then for Wipro India, he worked for some 2 months. There they deducted TDS, and I think she couldn't get the refund. She has some
Yeah, you could probably go ahead and check. Definitely there is a possibility that you can claim it as a refund. Some companies leave it to the employee CA to go ahead and then file this TRC and then claim it as a refund. So if you are encountering the situation,
you have to check that other countries treat it.
Definitely. See, all the treaties
Because Japan, in case of Japan it could be, but some other countries.
all countries treaty is the same. Yeah, in my experience, every country's treaty, there is nothing like, there is no challenge in terms of the wordings in the draft treaty. Most of the countries have the same wordings. So definitely you have an opportunity. Yeah, that you have checked, but definitely it will be included.
Point, can we add? Most of the things here, what happens is, when they practically file the return, they commit error in filling up the ITR form.
Yeah.
That is where they do not get the refund or
Sometimes people file it as a resident only, they are not bothered about the residential status. They say like, I receive only a small income interest and small salary income. So I have seen many situations where the person has filed the return as a resident. They say, I am having only interest income and some small salary income on the TDS is already deducted. Why should I actually go and check with someone? They will have filed the tax return. Otherwise, they lost the opportunity to claim.
So in this case, TRC also has to be
Obtained.
NF also has to be.
Yes. In any case, it's better to obtain the TRC and keep it for records. Otherwise, authorities do not have any ways to consider. Depends on how much quantum of refund are you expecting, is worth the effort or not. So if the income is very less, then if the person is not wanting, the 10F actually comes with a cost. The TRC that you have to obtain in the other country, it comes with a cost and also with the effort, right? So it also depends on how much you are receiving in India. If it's just a matter of very small amount and you are not even, you are claiming under the new, if the person chooses new tax regime and there is no tax in it, then it's not
worth it.
Yeah, it's not worth it. And then the same exact work from home situation that Sriram covered. R is a citizen of India and then he's a tax resident employed by XYZ Inc., which is a US company. And she receives her salary fully outside India. No part of salary is received in India. And stays in India for 2 months to take care of her parents. And she works from home. She says that my mom is not well, I'm coming to India. And these are the situations that we see also. Like, so can we say that this person is exercising her employment for 2 months in India? She is working from India. Can we say that this person is taxable for 2 months? Yes. She is taxable. But there is an administrative inconvenience. So what do we do? Just for 2 months, I don't want to break my bank paying 30% tax in the US and 30% tax in India. Right? That is why even though we blame the tax laws as well as tax treaty, there are times where we have an exception. Okay? So there is an exception in Article 15 which says that always it is taxable in the source country. Wherever you are working, that country has the right to tax. But there is an exception. If you work in a particular country for less than 180 days and your foreign company is not having any base, a fixed base or PE in that country and you work for a foreign employer, then you continue to get taxed in the resident country. There is an exception available in the paragraph 2 and which most of the people used, Indian nationals were able to use during COVID times. Right? So while it is an income which is deemed to accrue or arise in India as per section 912, but you will still have the liberty to go ahead and use the treaty provision which is more beneficial to the assessee. Because Indian government had to come up with a circular because it's not just the treaty countries, people didn't come from the treaty countries alone, they have come from the non-treaty countries alone. So the government has to issue circular to give relief to a few individuals who are coming into the city. Then we come to independent personal services. The first one, the salary is called as a dependent personal services because you are dependent on the employer. That's an employment contract. Here, independent personal services means you are at a free will and you are an entity altogether. You are, let's say that you are an independent chartered accountant or an independent artist, independent a person who is carrying on business. So to them, this is applicable. In general, our income tax, under the Income Tax Act, for example, let's take a watercolor artist, right? He is a watercolor artist based out of Europe, in let's say any country, Germany for that matter. He paints every single city, right? He comes to that city as a tourist, paints every single city and then goes back to his home country. And his work is appreciated by everyone. He comes to India, there is an exhibition in India by Indian artists. He comes and then comes for a guest lecturer to India to say how this painting has to be used, how my technique is used in my art. And then he is definitely going to be compensated by the person who is conducting the exhibition. He receives a small consideration for his visits, probably reimbursement of his expenses. Is that to be taxed in India? So that is the answer is there in the article. If you see the section as such, everything is getting taxed because as per our domestic provisions, as per the Income Tax Act 1961, every single thing will qualify as fee for technical services because the definition is wide enough to cover management, technical or consultancy services. Every single thing will get covered. So there is no doubt about the taxability under Income Tax Act. So how do we apply treaty? Is there a way out? So that is where we go to Article 14. This is based on the UN Model Convention. Then article number probably would differ in each treaty depending on what you see, but generally referred as Article 14. So in OECD Model Commentary, this article got deleted in 2000. They felt that why should we have a separate one when we have business profits? So let's club it with business profits. So that's the thought process behind OECD Model Convention, and they deleted it in their 2000 version. UN Model Convention is still having the article on independent personal services, and fortunately, all the treaties that India has entered into have Article 14 on independent. I don't think there is an exception. Very, very rare exceptions. Most of the countries that we have treaties with, we have independent personal services. And it is taxable in the country by way of thumb rule. It says that the person is taxable in the country in which the person is a resident, because may also be taxable in the country if he stays for a particular period, more than a particular period, or he has a fixed place in a particular country. For example, the same watercolor artist that we were talking about, if he is a resident of Germany, whatever income that he receives from India, from the Indian exhibitors, it will be taxed only in Germany, because he is actually doing it as a guest lecturer or he is doing. So there is no fixed base with which he is operating in India, or he is not staying in India for a predominant period of time. So therefore, then an exemption is provided in the income tax act. So in general, if the person is having a substantial activity and which is in the form of a permanent establishment, or let's assume that he opens a separate tuition center, right, and then he teaches and then he appoints a few people, then you can say that whatever income that he has earned is attributable to the particular tuition center. He is just coming on a lecture, so we don't have to tax and we do not have to add so much of administrative burden for individual related services. So that is the reason why this exception you can find only for individual related matters. For example, employees who are traveling, or for independent personal services where people are coming and then sitting here as an individual, as a natural person. So this kind of exception is not there for artificial persons. For example, in business profits, you will not have any such exceptions. Or in the case of dividend or interest, you may not have any such exceptions, because some kind of consideration that treaties want to provide for people who are not natural persons, who are artificial persons. So what if this article is not present in the treaty? If the person works in the independent capacity, right, and he is doing it as a business, it will be taxable as business, or it probably will get taxed as fee for technical services. Even if fee for technical services is not there, then it will be taxable as other income, which is there in most of the treaties. So that's how it operates. So just I'm an old school, so for every single thing I have reproduced the entire OECD Model Convention as it is there in the website. This person is taxable only in that state, which is only in that residential state, except in the following conditions. If he has a fixed base in India, it may be taxable in India, or in aggregate 183 days on any 12-month period. So this is as per the OECD Model Commentary, and this any 12-month period may or may not be there in a particular treaty. You will have to see treaty-wise analysis, but this is the thumb rule. Either they should have a fixed base in India, or they should have stayed for a substantial period for that income to get taxed in India. So who is covered? If we have to split and then see, one is activity based, the other one is they have listed the professions also. Okay. So the term professional services include independent scientific, literary, artistic, educational or teaching activities, as well as independent activities of physician, surgeon. So here they are defining their qualification. In the first one, they are defining what they do. So both people can be covered, and both the services can be qualified as professional services. Depends on what they do and also depending on their qualification. And what is excluded is if these clauses are already, if they are performing the same activity as an employee of a company, if you are doing it in independent capacity, it is Article 14. But if you are performing the same activity as an employee of a company, then you go back to Article 15, which talks about dependent personal services. This can be accessed only if you are rendering the activity in your independent capacity as an artist or as a physician or as a accountant. And any industrial and commercial activities are also excluded because you may not be it's a substantial one to give an exemption. So we are not, the activity is not giving exemption for this. So let's do a small example. J is a British national and he is an architect by profession. He is a tax resident of Singapore and he provides services as an architect in his individual capacity to a company in India. So he's a non-resident. He's a non-resident of India, resident of another country. He comes to India to provide services to an Indian company. He stays in India for less than 60 days. He has no fixed days in India. In this situation, will he be taxed in India?
Yes.
No. Because he has, though he has made the source of income, his source of income is from India. However, the exception kicks in. He will be taxed because he stayed in India for less than 60 days and he has no business base in India. It is not getting taxed. Agreed that the money is paid out of India, but there has to be some place where an exception is provided to avoid the administrative inconvenience. Otherwise, we will have a lot of tax filers in India. And it will be totally chaotic. The entire country or the entire world will only be doing tax filing. So, any questions so far? Yes. Absolutely. Absolutely. It will get taxed. Yes. Yes. That is the importance of this section. If it is not there, then that person is definitely taxable as fee for technical service, and whoever is paying, right? Because these people are whoever receives the money or non-residents, he is required to apply when he makes the remittance. He has to apply the TDS according to the treaty, which otherwise would have been 0, but now it will be a 10 or 15% depending on the treaty. They felt that even if you are not coming in, we would like to consider it as business profits, and some of the provisions would talk about it, whether you have a fixed base. Unless you have a fixed base in India, unless you have a fixed base, right, even the business profits will not get kicked in. So they felt that it's a repeat.
Unless and until, according to me, if they have any benefit, they will not do that.
Correct.
If they have done it, as of now in this case, maybe it looks like it is taxable, it may become taxable as an FPS, but as a hindsight now it looks like there is no fixed base.
That's right.
So here also there is no fixed base, and even I think in 5 also if they go, then there will be no fixed base and they will come out.
Right.
So if even FPS, I think they will go for gate available and still they would like to come.
Correct. See, as far as domestic act is concerned, this person is definitely going to pay. As far as income tax is concerned, it is definitely FTs, no doubt. But if you come to the treaty and assume that Article 14 is not there, it will be fee for technical services. And even if you do not qualify for fee for technical services, then it probably will become business profit. So, in
No fixed base, they will come.
yeah, no fixed base.
But he can't come in fixed base, so he's doing it in his individual capacity. So
No, she is talking about if this clause itself is not there. See, here we are talking about a situation where Article 14 is there. Article 14 talks about the fixed base and as well as the number of days of presence. The question is, what if this article itself is not there? What would have happened to that income? So there would be a situation, if it is not there, what will happen to that? So that's what it is.
So that they are trying to avoid the money.
Absolutely.
It is not sorry.
We'll make everyone pay tax in the country where the income is arising.
They want tax only in their own country, not in India.
Yeah. So, director's fees. So we have different type of director. Nothing relates to a movie director. That is a separate artist. Huh? Probably yes. I don't think they are artistic. No, definitely directors are not artists. Not artistic. They are not performing anything. They are artistic.
They are managers.
Artistic. Yeah, they are managers. In today's term, hopping for budgets and then making sure that the movie happens, and then sales at the right rate. More PR work. May not. We will come in sport. There is a separate article for sportsmen. We'll have to see. Sports we have separate one.
This, say, Indian team coaches or say any country team coaches nowadays, they are actually not doing coaching work.
Right.
They are not actually even covering this covered under teaching activities per se.
Absolutely.
They
Absolutely.
are just managing it. That's what is happening.
So we have different type of directorship depending on the role that they play. Even in companies, you have you have a whole-time director. Then they call it as a non-executive director. Then we have in some companies we have independent director. So we have different type of terminologies for director itself. And some directors will be as good as employees. So we will have to clearly know what are we reading. So if the person comes and says like I am a director, you cannot directly invoke a particular section because the word director is there. So you will have to read their contract and then understand whether he is a director, is an executive director, then is that person, he or she is performing as an employee, or is he or she performing as an independent consultant? What is that person's role in that? So is that person doing this as a business, right? This person has retired and probably doing this as a business, working as a director in 4-5 companies. Is that what, as a providing some technical services, is that what this person is doing? All that have to be, needs a break.
You know the reason.
There's a switch.
Super.
Silent.
So they have made available this knowledge. So they could be paid as an employees, or they could be paid because they are sitting on the board. It could be anything. So we have to see why they are applying or invoking a particular article. And the payments could be in different ways. The way they may receive salary, they may receive sitting fees, they may receive retainer service, or probably receive a percentage of their net profits as a commission. It could be in various forms. It could be an employee arrangement where a proper offer letter is there saying that you come on board as, and then every employee will report to you. You are going to be a managing director of the company. The moment the person is a managing director of the company, yes, probably he will be sitting on the board as well. He will be receiving salary, may also be receiving other payments, so we have to see what it is. So in this situation, if the person is an employee, then it is Article 50, not the director of this section. Then he probably may be providing some technical services, we will have to see, and then he will be also acting as a member of the board. So if the person is acting as the member of the board, that is when Article 16 kicks in. There are two important conditions here. It says director fees. Interestingly, if you see Article 15, which is on salary, where we have read, we are taxing that particular individual from where he is working, right? From where the person is physically working. That is the country which gets the right to tax. As far as director is concerned, director fees is concerned, it is not in the country from where the employee or the individual is working. Whereas it is in the country where the company is present. Only that country has the right to tax. The reason is, you are anyway claiming that particular country is given deduction for profits, right? Deduction for this particular payment. So there should not be any shifting of revenue from one country to another, and to ensure that this income is getting taxed in the country where the company is present, because the company is claiming deduction for this payment in the books, and the same country where the company is present is also considering this as income. So there is no shifting of income from one country to another. So that's one of the reasons why it's only the resident country, the company, in his capacity as a member of the board, of a company which is a resident of the other contracting state may be taxed in the other contracting state. So let's take it like this. Let's take UK as an example. We have already picked Europe and Japan. So if a director fees is received by a resident of UK, in his capacity as a board of director of an Indian company, which is a resident in India, may be taxed in India. So it may be taxed in India because the company where he is working as a director is a resident of India. If it's a company registered as per the Companies Act, then definitely he is kicking in, and then whatever director fees that he receives is going to be taxed. So what if the director never visits India? So I have already given the answer. So even if the director is not visiting India, doesn't matter. He can probably join on a VC or in a Teams channel or a Skype Zoom, can participate in the meeting. Nobody is bothered. You cannot say that I have rendered services outside UK and it is taxable only in UK. That kind of argument will not be acceptable because it's a different section of it. Okay, I don't know. I have put it. Okay, this is the subject. So there is Miss X, and she is a resident of US for 24-25, and she is on the director of board of ABC Limited, which is a resident in India, and she receives 10 lakhs from the company as a director fees. So what happens is, to give you in a nutshell, this company is ABC Limited is a resident of India. And then because director fees paid by ABC Limited is taxable in India, this person, Ms. X, being a resident of USA is of no significance because this company, ABC Limited, is a resident of India, this income is going to get taxed in India. And this Ms. X is required to file a tax return in India. And then taxability as far as the US is concerned, definitely based on the citizenship, she may get taxed in US on the worldwide income, but whatever tax that she pays in India, she can probably take it as a credit in her own country of residence. The second one is the case law, and the Authority of Advanced Fees, which is really an interesting one where a combination of things occurred. Okay, so this person is a citizen of Germany and a non-resident in India. And they have a consultant, he had entered into a consultancy agreement in Perumal India Limited, and he was appointed as a non-full-time, non-resident additional director. This is the exact terminology which is there in the okay. So the applicant received what, the main point here is what he received. He received the consultancy fees from the company, commission, sitting fees and reimbursement of expenses. So when he made an application, what the person felt that a person is operating in the independent capacity, so it's not a company. He's an individual. So he felt that he should be covered by Article 14 because all these payments are received in his independent capacity. But the AR felt that no, this is a fee for technical services because he is, or it may be a director fees. So we need to see whether it is a director fees or fee for technical services, or should anything more at all we should add. So that's the situation for this particular individual. So for one thing is very clear, he's a non-full-time, non-resident additional director, and anything that you receive as sitting fees, any person receives as a sitting fees, they will receive only if they are part of the board, right? So as far as the sitting fees is concerned, there is very clear case that it will be taxed under the director fees article, no doubt about that. The doubt is only with respect to these payments, consultancy fees, commission and other expenses. So AAR had the feeling that this person is an expert and he provides consultancy. It looks more like a consultation agreement, and therefore whatever, and it's one single agreement, it's not multiple agreements. He never had a separate consultancy agreement and separate sitting fees agreement and separate agreement for reimbursement. It's one single agreement. Even if it is separate agreement, you know that our authorities can actually look everything as a whole, but doesn't matter. Here it was one single agreement. So one single agreement covering a lot of expenses. So mostly people felt that no, it looks like in the nature of consultancy and we need to tax this person as this consideration should be considered as fee for technical services and not as director fees or not as independent personal services. So what the AAR held is that if you have two separate provisions and then wherever the authorities feel that this person is escaping tax, if you go into Article 14, because he is not substantially present in India, and then there is always an opportunity for you to go back and then use the fee for technical services article and make that person pay tax. So that is not the objective of the tax treaty. Tax treaties must be applied if there is a specific section. That specific section must be invoked, and if there is a beneficial provision in the article, that particular beneficial article must be invoked. So going by this arguments, the sitting fees was subject to tax under Article 16 as director fees, and the other consultancy fees and every single other payments was said that it is subject to Article 14 and it is not subject to fee for technical services, because when there is a specific provision, you cannot go back to another provision. So this person is, there is no doubt that this person is operating independently. The person is not operating as a, it's not a separate legal entity or a company to qualify as FTS. When there is a specific provision available, apply that specific provision. Just because that person is not getting taxed, you should not get annoyed and then put the person in another article and then tax and make an argument to tax another article. So that's the rationale for this. So any payment for that matter, there is no, the essence is any director fees requires a lot of investment in time to understand the kind of arrangement and what is the nature of payment, and to classify it in appropriate buckets. So there is no straight one answer fits for all, but blessed if you have an article 14 there.
Yeah, that's given fair kind of but most of the cases what I have read in AR, totally against it.
Absolutely. Sometimes some people are really interested. Yeah. Probably they didn't want to mess it up also, because sometimes like the Vodafone kind of controversy, it's like maybe 5 big companies and just 5 rulings. But these kind of, if there is a negative ruling, then it's going to jeopardize everybody's transaction.
I just wanted to show whether consulting or director's fees. Here the person is a consultant. Absolutely. Since he is a good consultant, that's why he has been taken on board. Absolutely. So his services are in the nature that he's a director and he's providing that services, consultancy services.
Correct.
So it's more the trust is on directorship. So that's why it should fall under that.
Absolutely. Absolutely. That's another way of looking at it. But as far as the section on the directorship is concerned, here if you see, these payments cannot be considered as consultancy fees. The consultancy fees is not provided to the employee because he sits in the board, in his capacity as a member of board. So the consultancy is not paid because he sits in the board, not in his capacity of a director, but it is paid because he is providing some consultancy. If he is actually sitting in the board and then adding value on the discussions that are coming up with the board, that is why you are paying sitting fees. To that extent, yes. And if you are providing something more, right, more than what you are expected to do with the board. For example, if you are, let's say, a direct tax committee, you are framing a direct tax committee. This person is working, let's say it's a company, India as a company. Let's imagine India as a company, and we want to revamp every single thing, and then we are coming up with direct tax. You are considering one person as the board, and you are also taking some consultancy from him on how to change and what section. You being an expert, you sit on my board, plus you also tell me what paragraphs I have to insert. So sitting on the board and then managing all the arguments that are coming in and hearing the representations is one role. Plus you providing some of your recommendations to insert that into the direct code, that is a different game altogether. Right? You are adding value to the computer.
Yeah. Together because sitting fees is for that particular meeting, attending that meeting.
Correct.
The inputs that you give is basically a consultant they have actually split according to meeting.
Absolutely. So it's a very thin line. It's a thin line, but depending on the role, that I have not seen what exactly that person does say in this case. But if that is the case, then I could have given you a different answer. It all depends on
the facts.
Yes, it definitely depends on the
Only
price.
if the SSC had not got to the area and got normal goods, then probably that perhaps opinion would have.
In that case also, FTS and the trade booming, the different way they would have thought.
There will always be a clash on whether it should be FTS or independent personal services, and mostly independent personal takes an upper hand in the absence of, and most of the FTS clauses will say that it excludes IPS. Right, so it excludes IPS very specifically. When it specifically excludes IPS, you cannot actually go and then fit this person into FTS. So that is what is another. But sometimes it excludes, sometimes they may accidentally omit, specifically calling it out that IPS is excluded. But as far as how you have to interpret the treaties is the same. Whether you make it as subject to or you make it as a separate one, the answer is the same. If there is a separate one, you have to respect that separate one and then say that it is taxable only under IPS and not as FTS. Welcome Vijay for tradition and social science.
Sridhar sir, actually, so what is defined as social security? We have Article 18 of the OECD commentary, which gives us a few features based on which a scheme is going to be considered social security or not, right? Because each country has its own social security schemes, and each of them operate differently, and each scheme is customized to cater to their own population, right? So in that sense, they would like to make sure that whatever is qualifying for benefit under specific article, they have met the basic minimum requirements as qualifying as a social security scheme. So in these things, first thing is mandatory protection provided by the state. Whether this is a voluntary scheme, this is going to be mandated by the state for every employee, or this is work, that is going to be the first condition based on which a scheme is going to qualify as a social security scheme. The second one is going to be, what is the purpose of this particular scheme? Is it there as savings? Is it there to provide retirement benefits? What is it that we are trying to achieve, or what is it that the scheme is trying to achieve? And the last one is, what is it available to everyone, or is it going to be available only to a specific set of population? For example, if it is going to be only for government employees, right, that the other population will not be eligible to take benefit from the scheme, whether this will qualify for exemption or benefits under the double taxation of items. With these things in mind, let's see whether the Provident Fund would qualify as a social security scheme under the direct tax under the direct taxation policy. So what we have under EPF and pension schemes, that this is mandated by a central legislation. We have the Employees Provident Fund and Miscellaneous Provisions Act, which is mandating contributions for everyone. There are exceptions. You could become an excluded employee. You could take in the exceptions and benefits for not contributing. If there is an organization with less than 20, you cannot contribute. All it is there, but still it is a mandatory protection that is given by the central legislation. Then, what is the purpose of this is that there is regular contribution which is provided at the age of retirement. It is to meet your financial needs when you have completed your employment age, and when you are going to need financial assistance to continue your livelihood. And then the old age pension payments, it need not be just old age pension, it could also be any financial assistance to mitigate at a point of certain situations, which could be maternity, which could be disability, which could be any such event like unemployment also. So since we have all these things covered under the Employees Provident Fund and pension scheme, PF could qualify as a social security element for the purpose of tax credits. In addition, we also have social security agreements, bilateral agreements with about 20 countries, where Provident Fund is considered the social security scheme of India. And if you are able to get a certificate of coverage from the
social security authorities of the other country, then you need not contribute to the corporate fund in India. So that is one more proof that we have to qualify as social security for the purpose of or for this purpose. When it comes to Income Tax Act, what is going to be the taxability of any payments that we receive as part of the social security schemes in India, which is going to be, we could put it under two categories. One is going to be the monthly pension that someone receives after they retire. That is going to be taxable as salary. There is a clear-cut section for that. And the lump sum payment could be exempt, could be taxable, depends on satisfaction of certain conditions that we have provided. If you are going and even though we have two main portions for which this taxation happens for social security payments, there is also section 8 and 8 which may not have much application in the context of NRIs and OCIs. That could apply more of Indian residents going out for employment and then their foreign social security contribution becomes taxable. We just quickly touch upon section 8 and 8. The purpose of section 8 and 8 is to make sure that you do not pay tax on accrual basis from your foreign social security. Right? That is, you may go this year and you might be eligible for withdrawal or redemption only after say 5 years. For income that you will be receiving 5 years from now, you don't expect you to pay tax now on accrual basis, which is going to put a lot of financial hardship. So what this section does is, this has been introduced only from 20 to 23. What this section does is that it allows you to pay tax on your foreign social security income on receipt basis. It does not provide an exception, right? What you have to pay tax on basis and becomes taxable on receipt basis in the year in which you redeem or withdraw the contributions. There is a form that needs to be filed before the tax return filing today, similar to the forms that we file for claiming FTC. And as of now, there are only 3 notified countries: UK, USA, and Canada. So if you're going to UK, if you have someone who is leaving India to UK for employment and they are paying social security there, they may be eligible for claiming relief under section 890. Again, it is not exception, it is only just moving the tax liability from this year to the year in which you are ready. Any questions before we move on to?
So that would be on prohibitions.
In general, it is on accrual. So anything prior to this assessment year, it would have been taxed on accrual basis, right? So what this section also has is that, so when you are going to take benefit out of this, when you are going to file Form 10 and you want to offer that income to tax on receipt basis, if you have already paid tax on one portion of the income, say in before this section 8 and 8 comes into place, then when you actually finally offer it for taxation on receipt basis, that income will not be taxed again. That provision is always there, right? And it again has 2 more exceptions, right? If you are going to be a non-resident, which means that it's foreign income, it does not have, there is no taxation right for India, obviously that is excluded. And if you have applied treaty benefits, it becomes taxable only in the other country, again it will not be included. So it has very limited applicability, especially in the case of NRIs and OCIs, right? So for this purpose, the person who is leaving for the purpose of employment, he still qualifies as ROR in that year, and they would take benefit here or in the year in which they return. So for NRIs and OCIs, this may not have much applicability, but we still wanted to touch upon 890 because it's part of social security and pension taxation. When it comes to tax treaties, we have, depending on the specific treaty that we have,
it would be Articles 18, 19 or 20 that deal with pension and social security payments. And in most cases, pension or social security payments are taxable in the country in which they arise. And they have also mentioned that it will be deemed to arise in that country if the payment is made to the government or a political subdivision, or if it is going to be paid by a local authority of that particular country. So this is going to be the deeming status, and this is going to be so in most cases, right? Except if you're going to go in, there's going to be an exception. It is going to be taxable in the country in which they arise. And also looking at the nature of payments, some treaties do not define pension. They just mention that pensions are taxable in the contracting state in which they arise. That is one. Say, for example, Japan has that, Canada also has that kind of wording in the tax treaty. There are other treaties which are very specific about what is covered in the pension. For example, the US treaty says pensions are going to be periodic payments made for past services or made for compensation for injuries sustained during employment. And then you have UK DBA, which says it could be periodic payment, it could also be for past services, which means that even lump sum payments could come into that particular definition. But in US treaty, you might have to see whether it is going to be part of the pension article, or if you have to go check the other articles like dependent person services or other articles. So each depending on the specific country, we will have to see which article it is going to come under depending on the wording that they have used. Any questions, so we can pick an example. So this is an individual who is working for an Indian company, and he retires at the age of 60 and he moves back to the UK. Right? During his employment in India, he has contributed to Provident Fund, not to pension, it started in 2019. So he is contributed to pension in India, and he applies for withdrawal of his Provident Fund contributions upon leaving India. So, if you are going to look at Article 20 of the India-UK DBE, it says it is going to be taxable in the country in which the recipient is resident. And by definition, pension also includes payments made under the social security legislation of that particular contracting state. So, in this case, the recipient is going to be, they will have to determine in the year of the year in which he gets the PF withdrawal, which country is to be a resident of. And then, since this, whether this will come under Article 20 or not, it will still come under Article 20 because this is a payment made under the Social Security legislation of India, which is the EPF. Yeah. We will have to see. Right? So let's look at two scenarios. Okay. The first scenario is where the lump sum payment is made in the month of May 2024. Right? This person has already left India and UK in November 2023, which means that for the financial year 24-25, he qualifies as a tax non-resident in India and a tax resident of India. Right? So, as per Article 20, wherever the recipient is a resident, that is where it is going to be taxable. He is a UK tax resident, it will be taxable only in the UK. There will be no taxation. That is scenario 1, depending on residential status.
And one practical problem or situation that may come is this person has worked in India only for a very short period of time, right? It's less than 5 years. If a person has put in less than 5 years of service, then PF office is going to deduct taxes and then only pay the balance. So there you cannot go ahead and then explain DTA. They are not like companies who will appoint a consultant to determine whether it is domestic act or necessity, whichever is beneficial, we will do 50 CACP. That's not the way they operate. They will straightly put it at 30% and give the act gross and give the balance sheet. So if this situation is encountered in a practical situation, then that particular person has to file a tax return, claim this money as a refund by quoting Article 20 and then also attach the TSC. And then prove that this income will also get a tax. Because India and UK are the same financial year, we also follow the same financial year concept. There are chances that he may, if he is a resident here, maybe a non-resident, and vice versa, because we follow the same concept of physical presence, same concept of financial years. Normally, there will not be any conflict on residential status. You can claim a refund in the Indian tax return. So there are practical situations where taxes will still be rendered by the authorities or it could be by the companies on account of some practical challenges. It is for us to assess the particular person's residential status and also decide whether we want to claim any of the amount that the person is considering as a sunk cost as a refund back to this person.
Pension related to like the salary, that service is not. So in that case, it is not going to the place where the button.
Yeah, it's a very good point.
Yeah, we have a specific article for taxing pensions. This is Article 20, which is pension. The India-UK DTA. If it's going to be the India-USA treaty, where it specifically says only periodic payments.
See, for lump sum, it's a different treatment. For periodic payment, it's a separate treatment.
But again, pension is separately.
Yeah, the character doesn't change.
Character doesn't change. But the thing is, when you have a specific article, right? In India, UK DTA, you have a
I'm okay with this. The DTA provides, so that is what has been agreed upon. But what was the
It's earning. You have earned this entire money by serving India.
Yeah.
And India, see, there could be a unique situation. India is the only country that provides a lump sum payment and exactly the money, whatever you have got with some 8 to 12% of interest. Other countries normally provide a periodic payment only. There is no concept of lump sum. Probably even if they pay, it could be just 10% of the total accumulation. So that is one of the reasons why articles of the tax treaty probably could be unique when compared to the domestic tax systems.
This is periodic in the same financial year. They will
Periodic payment is every month.
every month or every
year. All the countries, including US or any country for that matter, they provide only monthly ratio.
So it should anyway be accumulated with will go along with the salary.
That's
so
right.
that this question will not arise.
That's right. That's right.
So, if you're going to take another scenario, right, same facts, except that the lump sum payment is received in the month of March 2024. Right. So, this person has qualified as an India tax resident for FY 23-24 and the UK non-resident for FY 23-24. Okay. Here it is resident in UK, non-resident in India. Here it is just resident in India, non-resident in India. Which means that based on Article 20, he is the resident of India. It becomes taxable in India, not in the UK. Which means that when you are filing the tax return, you could claim the TDS, pay only balance taxes, or if there is going to be, instead of 10%, it's going to be 30%, depending on how much TDS there is, you could recompute your taxes. There is no question of TRC or TNF or anything, just file your tax return immediately.
We have to take a small break or we'll continue.
How long will this be?
So that's half an hour.
Tax.
Ready?
How many get them? 10 minutes then break.
We will get refreshed.
Okay.
Ready?
Break.
Otherwise, it's like our
Start with other we are going to look at other income articles, except for treaties with 3 countries. We have other income articles on all. The wording is quite different, but how we are going to treat other income have a few examples here. In terms of income not dealt with, not expressly dealt with, or not expressly mentioned, could be any of these verdicts. But we have this particular clause in all treaties except for Libya, Greece, and the Netherlands. So, what is going to be classified in this is going to be whatever is not being specifically covered in any of the other clauses. And we have 3 clauses in the UN model relating to other clauses. Right? The first one is where the clause 1 says this is going to be taxable in the country in which the recipient is going to be a resident. Right? This could be present in most of the UN model conventions, and we have it in this one also. And then we have exceptions to this particular rule. This rule 1 is going to be taxable in the country of residence. Clause 2 is going to be exceptions to this rule. And then we have a third one, which is going to be right of taxation to the source country, which is going to be diametrically opposite of the first clause. Right. If you're going to look at treaties that India has, in most of the treaties, we do have this clause which says that source country has the right to tax, and India does not get to go of its right to tax that particular stream of income. We have a few examples here. It's going to be in the UAE double taxation rights agreement, where it says this is going to be for the resident country. Right of taxation remains with the country in which is going to be a resident. We have the India-US where we have the source country. And then we have a few other tax treaties where it is going to be taxed based on the domestic tax. India Singapore is one such example, where anything which is not covered in the previous clauses or previous articles, they are going to be taxed in accordance with the taxation to domestic tax. So, depending on which treaty we are going to be looking at, which clauses it has, we have to learn individual interpretation for each such case. It's just a quick example. Right? This is going to be an India resident who has received pension payments from the employer of her deceased spouse. Employer is a UK resident, the company is a resident of the UK. The recipient is Indian resident. So whether, and at the time, like how our EPF deducts taxes are being deducted on the pension payment while making the payout. Right? So the question is this pension taxable? And under which article, if you are going to go to the tax treaty, under which article is it going to be taxed?
Usually, the employee gets it, then only it will be pension. Otherwise, it's a spouse. Family pension, specific name, there's nothing in the DGWA.
Nothing in the UK taxation.
That's why we fall under the.
It will fall. Right. So this is going to fall under the other income clause. Right. In the other income clause, the third clause, because the first two do not apply, the second one is going to be for immovable property, the first one is going to be for something very specific arising. We go to the third one, which says it is going to be where it's going to be arises. It is arising in the UK, so it is going to be taxable only in the UK. It's not going to be taxable in India. So this person would have to find might have to file a tax return in the UK because it will be taxable there, and there have been taxes already deducted also. So the person can claim credit for the taxes and then work on the balance taxes. Then it is going to come into India as tax-paid money because it's already suffered taxation in the UK. It's not going to have the specific taxation. So this is one classic example of other income which is not specifically called out in Indians. As you said, it's not going to be pension because the basic assumption is that there is no employment relationship. We move on to credits in NRI.
Mostly like whatever money that anybody receives out of lottery, gamble, because these are very famous in countries like
US.
Yeah. So if you get some
Gambling views, right? You win something in gambling, right? You go to, Las Vegas casino, you use the slot machine or card games or whatever. Whatever money you win out of gambling, that would come under other income articles. Or other examples that are there in the US Model Convention is that any punitive damages that you have received, not compensation, but punitive damages, that will be one of them. There could be any guarantorship fees that you are receiving within the group company. Because you are not a company where you provide guarantorship to outside the parties. You do it within the group, then that will come under other. Guarantorship, where you are providing guarantees, right? And you are paid a fee for the guarantorship. Yes, that one, if you are going to provide to your group companies, that will come under other income. If you are going to provide it as a service to anyone outside, as a third party, unrelated third party, that is the main business of yours. That will come under business profits. So there are specific examples followed out. Again, it has to be an individual analysis to see if it's going to fit under any of the specific categories, and then bring it under residuary class. So catch.
Morning in the session you were mentioning that lottery winnings and all in the FEMA or something you can.
That is whenever you want to remit. And the funds, whatever is there in India, whatever available which cannot be remitted by a foreign nation. Is it that is a scheme or that $1 million scheme?
That is.
Say, anything which is coming out of race and also lottery and gambling, other thing that you can't remit it. Simply remit it. Then the 250,000 or 250,000 for the resident is for the general revenue, whatever you are getting it, you can remit it for the purposes. But simply you can't remit it. The reason why it was introduced was during this housing time. See, they have to make it open, they open it, but you can't allow it, everything has to come. Now the government is feeding it. Today morning, 700 billion is the forex. And also even 100 billion goes out also, no problem. But now, madam, it's okay. Finance Minister has put check on 5% and also 520, another 5 and 20% is TCS. She has put. Okay. 0 is also there. 0, 5 and 20 is this is. Then now we are getting confused with whatever this with FEMA and income tax and this.
That's right.
See, FEMA is permissibility of transaction as such. Here, even if it is unlawful income, we say that it is taxes, right? So we are that here it is about tax. The first one, FEMA is about permissibility of the transfer or the service as such. Here, whether it is permissible or not doesn't matter. Here it is we are only talking about revenue tax. Where it should be taxed. The permissibility of the transaction is already out because the transaction has happened. Right? So here when it comes to
this TCS also, she has put the registered anything more than 7 lakh rupees not required also. Because they are not able to find out how much is going and in order to keep control of that they put 5% and 20%. For that also I gave in the morning some suggestion. How to do it whenever you want to replicate. 250, father can send it, mother can send it, grandfather can send it, parent can send it. Everybody will get it, okay. From the, if you ask for the university, they send to everybody, you connect it and send it. Don't send the equal amount. Send it 150,000, 16,000, 50,000, right? Because some of the university measurement, the money comes with, oh, sorry. I'm very sorry, I'm afraid we are sending multiple things, they remit it back to the students. We have to do a better. There is another route to answer. You understand? It's 15,000, 15,000,
that's what I'm seeing everybody.
Everybody is sending. Other people say, oh mother, grandma, I am very much love of you. He will send a letter. That letter copy and you send it. Don't send it to the income tax and bank, particularly bank. Don't use the same bank for the remittance. One bank, my father uses one bank. This one, the previous example which you are taking.
Yeah.
Okay, now I understood it is taxable back in UK.
Because it becomes taxable only in the UK, you will not have any taxation in that in India. There are a couple of case laws also.
So it shall be taxable only in their country.
But the thing is, here the question is, the person you want to tax is the person is resident.
Yes.
That is Mr. That is tax on the hands of Mrs.
Yes. That person is no more. The person who actually rendered services is no more. That is why the wife is getting the money.
Right?
Right?
I understand. Okay, now you can go.
Thank you. So, yeah. Supposed to be in the exempted law. Supposed to be in exempted law.
Gambling
Gambling is there.
Las Vegas is closing.
Las Vegas.
Las Vegas is
Automatically TDS is there. Sorry, TDS is there. It is there. TDS is even from the old items. TDS is
Even in Las Vegas, whether it is not there, we do not know.
Oh, which one you are
He is
talking?
talking about money in US.
Gambling income. People disclosing.
See, you get the money from that country. If they are deducting, see, there is a tracking mechanism, yes. I'm saying that, see, it depends on how much gambling. We had a client, I think he won how
What
much.
happens in Las Vegas stays in Las Vegas.
I know they will spend that money.
How they will disclose the Las Vegas gambling income.
Last where is money, whatever money you come for, there is there. Immediately there is a. Okay. You are all auditors. Right?
Yeah.
Okay, nothing is required. Immediately they make one understanding. This is hereby we put together and we join to the rules, 100 people join together. They sign the paper. We hereby, if this money comes, this is the audit, rectal audit. This money comes, we are all sharing it. Automatically it is distributed to 10 people, 100 people, 100 people. No, we have done it. Okay. When I was in the Tamil last field, then we just distribute, then it is a non-taxable. Only thing is, there will be one arbitrary there because he will collect the money, he will not distribute it with other people. For him, he will do the only commission. For example, he got at that time maximum 10 lakhs now he was charging. Yeah. Immediately, remove the Mr. ABCD 100 people, fan is there. ஆனா அந்த பையன் வாங்கிட்டு தரமாட்டாங்க. அதான் பிரச்சனை. அங்க வரவங்க தரமாட்டாங்க. அப்ப என்ன செய்யறது, அந்த ஃபேமிலியா போய் 100 பேருக்கு அக்கௌண்ட் ஓபன் பண்ணி விடணும். அப்பதான் என்னோட இடத்துல கேட்டாங்க, 100 பேரும் ஒரு அக்கௌண்ட் ஒரே நேரத்தில் ஓபன் பண்ணி, சார் டிக்கெட் எடுக்கும் போதே எங்களுக்கு வரும்னு தெரியும் சார், அப்பதான் ஓபன் பண்ண சரியா முடிந்த பிறகுதான் ஓபன் பண்ணிருக்கீங்க. அப்படிட்டாங்க.
அப்புறம் டாக்ஸ் பண்ணாம
அவங்களுக்கே தெரியும்.
See, if you get the money, probably, if somebody is disclosing, then take it. Or if the money has come into your bank account, it's a significant money has come into your bank account.
into the banking.
Otherwise, if it's done, spent, no TDS, no tracking, then
There's nothing.
but many countries actually formally take your hand.
No, that at the time of the TDS was that we had to connect back the TDS. எல்லாரும் அப்ளை பண்ணி TDS இருக்கணும் அப்போ இருந்துச்சு. I'm just talking about 1973. அதுக்கு உட்கார்ந்து பண்ணணும், அதுக்கு ஒருத்தர் இருப்பான், அவங்க அடியார் மாதிரி இருப்பான். அவன் வந்து இந்த பணம் வந்த பிறகு இந்த எடுக்கவே விட மாட்டான், பேங்க் மேனேஜர் உட்காந்துருவான், எடுக்க விடாத மாதிரி. அப்போ வந்து ஃப்ரீசிங் எல்லாம் மேனுவலாக தான் ஃப்ரீசிங், லெஜர்ல போய் எழுதிடுவானுங்க, நாட் டு ஷோ, நாட் டு ட்ரா, பென்சில் எழுதிடுறான், பென்சில் எழுதி வந்து சரி, அப்போ ஸ்டிக்கரும் கிடையாது, ஒரு இதுவும் கிடையாது.
Online transfer இல்ல, கையில வந்து தான் வாங்கிட்டு போடுவாங்க, they were in a position to put that resolution.
அதே ரொம்ப ஈஸினா இப்போ பேக்கா மெட்டீரியல்னு ஒன்று இருந்துச்சு, நான் சொல்றது நசிவான், அதுதான் இப்போ வந்து இவங்க எடுத்துக்கிட்டாங்க. ஐசிஐசி சரி, this RPA.
So credits in NRI account, I think you already had this hour.
Doubt is clear.
So who's eligible to open this? Anyone who can qualify as to Congress, India, AO or OCI, they are eligible to open that. And the purpose of this account is to deposit in foreign currency, use the funds to manage any expenses or investments in India. And when that person comes back, that is, the person opens his account when he is having a non-resident status, when he is going to come to India and he becomes a resident, this account will normally be designated as resident account.
This only one small clarification. This is upon permanent repatriation to India, accounts to be redesignated resident account upon returning back to India.
Yes.
This is as per FEMA rule.
Yeah, this is as per because it's for bank account. So this
No,
is
that is bank account. Here, return of repatriation, return of this man, you come back permanently without employment, or you are coming back thinking that you will be going to be employed in India, then you become Indian.
Yes.
Then immediately we are to
Yes. When you become a resident as per
in this only one clarification. FCNR deposit rate, it cannot be converted. That's what they are saying.
that is because this is going to be an NRE account.
NRI account.
Right.
If FCNR means, FCNR also, you can wait until 5 years FCNR and 10
Right.
years FCNR.
Yes.
Then FCNR until the maturity, you can continue.
Yeah, you can.
Continue, and also this is another, under Income Tax Act, okay, you will get the benefit of 3 years benefit for the interest earning out of that on the, okay,
If as
not
long as
ordinary resident வந்துரும்.
correct.
ஆனா
As long
அதுக்கு அவங்க
as
5 years வச்சுட்டு,
Yes.
5 years வச்சுட்டு அதை அப்படியே வச்சிருக்கலாம் in foreign currency. அப்படி பண்ணலாமா?
If bank allows, see today bank
Bank is allowed.
Okay.
Bank is allowed. Only if FCNR A they will not allow. You know what it is. If FCNR A deposit was there, that they will not allow. FCNR B they will allow. Otherwise, immediately write to the RBI, they will immediately fine.
See, the moment today the banking tracking systems are highly effective. The moment they see a transaction originating from India, if you receive a salary or you receive any transaction, a lot of transactions which are receipts from India account, it's not FCNR account is a deposit under what customer ID, correct? Every bank has got a customer ID, and they under the customer ID they will associate savings bank, fixed deposit, FCNR, NRI, and you have a lot of accounts. So when banking system manages, earlier bankers were managing, now the systems are managing. The system is now very sharp, and the moment you are seeing a lot of credits from Indian sources, it automatically triggers or provides an exception to the bank and saying that this person has become a resident. All these accounts have to be converted to resident account, and then the company bank's relationship manager will force you to convert to a resident account, saying that it's otherwise. But if it is not a bank where they have this kind of tracking system, and you are still in a position to do it.
FCNR they will maintain. They will maintain the only clarification is 5 years means 5 years you can take. Nowadays they are not keeping 10 years FCNR. 5 years. The 5 years, when coming to Income Tax Act, it is up to 3 years, the interest is exempted.
Correct.
Yeah. Even though you become a resident also, because you are coming not ordinary resident, then you 2 years வந்து ஒரு இது கிடைக்கும், ஒரு float உங்களுக்கு கிடைக்கும். அதனால
Okay.
ஏன்னா money can
So you are talking about the last 2 years. Okay, I understand.
last 2
See,
years. இல்ல இந்த 3 years exemption 5 years வச்சிக்கலாம். அது எதுக்கு விக்கிறாங்கன்னா 2 years tomorrow you want to remit the money. Because it's at this string 10th to 12th, அது பண்ணாலும் ஈஸியா அதே டாலர்லயோ இதுலயோ அது மட்டும் இல்ல அந்த கரன்சியை கூட ஆர்எஃப்சியா மாத்திடுறாங்க. ஆர்எஃப்சியா மாத்தினாங்கன்னா ஸ்டேட் பேங்க் ஈஸி. இவெல்லாம் மற்ற பேங்க் எதிர்பார்க்கலாம்.
See, as long as you are a resident, the moment you have become an ordinary resident,
You must-
irrespective of what you do, is going to have to pay off for tax.
Thanks.
So 1042, there is a specific exception in NRE accounts. So if you are going to have NRO account and when you leave India, but NRO account does not have any specific exception, so any interest on that is going to be taxable in India, irrespective of your residence status.
இதுல ஒரு பாயிண்ட் ஆட் பண்ணேன். The interest from the first one will be okay. TDS will be there.
Yeah. So for the first one, there will be
No,
TDS.
sorry.
The second one, there will be
NRI there is no TDS. Down NRO account you have a higher rate of TDS of
That's right.
20.4 or 20.8.
If you submit a TRS, if you submit the tax residency certificate, then there is a chance for reducing the TDS itself.
Yeah.
So if that is the only source of money in India, you can submit a TRC so that banks don't deduct at a higher rate, they probably will deduct it at a lower rate. So that's one of the options. But given that most of the NRIs don't have time for planning and paying advance tax, most of the employees keep it as such and then they will file a return and take the refund or adjust it to their other income. So coming to the gift part, which is also a new amendment into the Income Tax Act. So generally, any gift, we have section 56 which covers any gift in the form of monetary payments, any money transfer between non-relatives, right? And without inadequate consideration, the chargeability is there in 56. But if you see section 9 as such, this was not there. So most of the non-residents who received the gift outside India from a resident individual said that this money is received outside India, and as a matter of fact this gift is provided to me outside India even though it is paid by a resident individual, so this is not coming in the India tax net at all. As far as a non-resident is concerned, unless it comes into section 9, it is not taxable there. So the government saw this as a potential tax evasion by a lot of people, and they have plugged this loophole by introducing gift also into section 9. So it's I would say it's a new one because it's last 2-3 years only it has been there. So it says that this is the last clause in section 9. Income arising outside India being a sum of money. So it is applicable only to money, not immovable property, because immovable property is already covered in another section. So it only covers the sum of money, and any sum of money, or when you see it here, it is covered by section subclass 24. So if you see what it says about whatever is there referred in section 56. So from section 9 refers to section 2. Then you come to section 2. Section 2 says the transactions which are referred to in 56.2. Then you come to 56.2. 56.2 says any sum of money without consideration and 50,000 or more. So that is what is considered as a taxable gift. Even in these cases, any gift between relatives or on a particular occasion like marriage, all those exemptions can be taken like a resident individual. Which one? Gift of jewelry on the occasion of?
No, maybe not on any occasion.
It will get taxed. So the obligation is any resident individual giving gift to a non-resident.
Not resident in India.
Not resident in India. So this even bankers started doing it.
Even to the relative also has to.
No, not to a relative.
Other than the.
So the exemption is there.
Okay.
Like whatever is there, whatever exemption situation which are mentioned in 56 will still hold good. Right? That exemption is there. But if these are, for example, transfer between two friends or two unrelated people for something which is not covered under any of this, probably they are trying to bring it as
Any threshold limit is there?
50,000.
Yeah, you told me.
So 50,000 or more, as in the case of the domestic transactions. So they will have to, any resident gifting a money unnecessarily without any of the occasion, there is an obligation to deduct this.
So money means here not only money, it also includes jewelry.
It also includes bank transfers. It's not just pure cash payments. It also includes bank transfer, money in the sense. But jewelry as such.
Because immovable is considered separate.
Yes.
Movable properties.
See here, as far as this particular section is concerned, no, jewelry is not covered here. So for jewelry, there is a loophole. You can give it as gold.
This is include the value of the property also.
And you have to give it outside India. You can buy gold in Dubai and then give it to your friend in US. Not a problem. Citus is outside India. Received outside India, accrued outside India. You can still do that. This section is only for about the sum of money. So that loophole is still there. And then as a person who is paying the gift, the person has to obtain a TDS. Obtain a TAN and then file the TDS return, and you will have to apply the other income article here, because if you are specifying, checking about under which section, as far as the Income Tax Act is concerned, very clear, it's anyway there in section 9, and you will have to show it in the income from other sources. But if you have to see what is the treaty beneficial condition, then you will have to apply other income. So again, there is I won't say a tax planning opportunity, but there is still if there is a beneficial provision in the article where once which is said that in some countries it is taxable only in the resident country. So in such case, in the example that we were talking about, if the person is non-resident in India and resident in another country, as per the Domestic Act, this income is deemed to accrue or arise in India, but as far as the article is concerned, as far as the treaty is concerned, it may be taxable only in the resident country. In such a situation, I think it's a tax planning opportunity, and then it gets untaxed or non-taxable in India. So that's the way you have to look at it. But most of the countries, if you see the other income where the Indian diaspora, the Indian nationals or NRIs are present, that reserves the right for the source country. There are very few exceptions where the other income right is passed on to the resident country. If somebody is planning, I don't know who this, they'll have to look out for a particular article and get it, become a resident in that country and invoking that particular country.
This is applicable even a resident giving a gift money to a resident also.
Yes, absolutely. Absolutely. So a gift from a resident to resident, anything which is received by a resident, you have a global tax kicked in, and then we can still, there is no doubt about a resident. The doubt is only for a non-resident, because we are providing an exception in the Act saying that anything that accrues outside India is not under the purview of Income Tax Act. So whenever you say that it is not applicable, and that is where the tax planning is done, and that is where income tax authorities think that we will have to bring it to the deeming fiction. It accrues outside India for a non-resident, not taxable. But if India thinks that this money is out of efforts out of the Indian soil, or the revenue should get taxed in India, then they insert a deeming provision and bring that money into, bring that particular chargeability into section. Bring that into the scope of taxable income under section 9.
But do you have an experience of some resident giving money more than 50,000 to another resident? Yes.
To a resident in India? See, as far as in my firm, I have not seen any such cases. But it's quite a common transaction, is what I know. See, now I know that I cannot be saying all this, but there are the same example that you have quoted. Somebody is splitting the money and then paying it to multiple people to avoid certain things. And that particular person, if the person is not a relative, this money may get taxed. For example, you can say like, I don't want to pay.
Splitting is splitting, not
See the same university case that we were talking about, right? Let's keep it like this. You have some 10 lakhs in your bank. That's why you should be very careful when you receive or send gifts. You have some 10 lakhs, and you are saying that 10 lakhs must be passed on to a university student outside India. People are splitting the money as 3 lakh, 3 lakh, 3 lakh to avoid TCS provision. Let's take and 1 lakh as TCS provisions. Sir is transferring to, somebody is transferring to his spouse.
He should not transfer. It should be from their money only, out of their money.
Okay.
It should not be transferred.
So if they do any of these things, then what can happen is, as long as it goes within the relative, it's okay. But if they say that it's a friend and then they are trying to do it, then that money becomes a gift received from an unrelated person, and that unrelated person may get taxed for that amount which has come into the bank account. So there are provisions where if you receive the money from someone, even between two residents, which could be an unexplained income but now characterized as a gift. So better be cautious if you are taking some money from someone, just to avoid any of the transaction. It comes into the bank account, can really get problematic, and the gift provisions will kick in whether you are a resident or a non-resident.
You have to get back the loan.
Yeah.
1 year time there.
That's it from my side. Thank you. Any specific questions?
No, I am just looking at section 56. 36, sir. There is property and property includes jewelry.
Oh, okay.
Whenever it has three words, that is cash.